ki mai te tāwhiwhi o ngā atua ui takena te Māori. O te Māori ahua nō ki runga. I nei tauraki, i nei tauira. Ke tau te Māori ke runga na tama. Ka puta ki te whaiau ki te ao marama. Uhi, wero, haramai ki toki. Haumi e, kui e, ai ki e. Aka nui te kōtapu. Nā kau e tuana, ke mihi ana ki a koutou. Komihana ki a koe te tiamana. Me o koutou ngā mema o te komihana o ngā karangatanga maha. Nau mai, haere mai ki o te poti. I tēnei wahi pito o toitu. I roto te takiwā kaitoru e heke heke. E tuku ana ngā mihi miharo ki o koutou. E tīmata ai tēnei whakamāhere here, kaupapa here. Mō tātou, o tā hāpori, o tākau, o tāgau, me o koutou, o rātou, tuku kōrero ki o koutou kātou. Koutou ngā kaiwhaka rongo, te tono, o rātou, me tātou, o kaitahu, pānui, mō tātou, hei hangai koutou ki te ture, whaia te tika, te pono, e whakahaere tēnei kaupapa mō te kaunihera. Nō reira, tēnā mihi, tēnā koutou toa, kia koe e te hoa, rangatira rau, ngō me mihi ana ki o tōna iwi a te whānau apanui, e kiti ana i te rākau i te kuiti, i te apology, i mani o poto, ka kanui te koe kiti ana koe koutou katoa. Kia koe Ellen, I mohi ana koe, mō ona tau katoa kia koe. Kia kōrua, e tūtaki ana kōrua no te wā tuatahi, e mihi miharo kia kōrua nau mai. Haere mai koutou katoa. Huri no o te ruma, he wā, he rā, whakanui mō te rohi nei. Nō reira, tēnā koutou. Ka huri kia rātou ngā tini aitua te wā, te weke, te tau, ngā mate huhu o te motu, kaua e wari chea o rātou, o haere kei runga tēnā ara o te ara whānui a tāne, kia rātou te hunga wairu, haere moi mai, oki mai, kāti, huri anō ki te kaupapa katoa, e tuana hau, he māngai mō te paukaika, me o tātou nei whānau e o kaitahu, mai te tiawa waitaki, tai atu ki Rakiura. E mihi ana, tautoko ana koutou katoa tōna mahi miharo, pēnā koutou, nau mai, haere mai, whakatau mai. My great pleasure to stand here this morning and welcome you to Otepoti, to this whare, commence this hearing. It's been a long time coming, a lot of work's gone into this, and you've got a few months to work through the various pono that are going to be laid before you. So we wish you the best in your work, and we look forward to the results of that. And of course, we're coming up fairly early in the process, so nō reira, we trust all goes well. Nō reira, tēnā koutou, kia ora tātou, katoa.
Manu tere a manu.
Ore, āwhi te hono tātā, hono mati ki te hono mati tātou, te hono ki a tātou. Kia ora tātou.
Ngā ke au ki te tangi a te manu, tui a. Tui ai runga, tui ai raro, tui ai waho, tui e roto. Tui a te here tangata karangote te pō, karangote ao. Tui e te kāwai tangata heke mai Hawaii ki nui, i Hawaii ki roa, i Hawaii ki Pāmamao, i te hono i Wairua. Ka puta te reo tangata ki te whai au ki te ao mārama au e ki ai. E ke panuk, e ke tangoro. Whāno, whāno, haramai te toki. Haumi e, hui e, tāhi e. Aka te e timatanga kōrero māku. Me wehi ki a ihoa. E aia ngā mea katoa. Nāna tātou i taipai mai ki konei tēnei rangi. I runga i te aha, i runga i te karanga. Ia whakawhaiti mai ki konei tēnei rangi. O tira te hunga wairua ko mene atu ki te pō. Ko tahi tonu te kororo ki a rātou what's. What's haere. Ngā mate o te mots. Puta no te mots. Ngā mate o ngā marae maha. Toho nei runga i te mato o te whenua. O ki atu koutou ki tuo pairau. O ki atu ki a rātou katoa. A nei ngā waihotanga rāke e noho nei. Nā reira, te hunga wairua rātou ki a rātou. O hoki mai ki a tātou i tēnei rangi. Tēnā koe Edward. E mihi nei ki te hunga ko tai mai ki tangi nei. Nara, e mihi nei ki a tātou katoa. Nā koutou te mana, nā koutou tēnei rohe tika ana, ma koutou tātou katoa e mihi, e whakatau. Reira, a kei whea ke he kōrero mo te ro ngātaki. Te mea nui ko ngai tahu tēnei, e mihi nei, kawe nei tēnei take, ko ngai tahu e whāriki hia nei ngā take katoa, ko mauri mai ki kone i tēnei rangi. Hei tirohanga mō tātou katoa. E tika anō tō kōrero, e take tēnei mō te ao whānui. E hara mō ngai tahu anaki, e hara mō o te poti anaki, engari mō ngā iwi katoa puta no te ao. Anei tēnei, o ngā mōka e te whānau apinu e mihi nei ki a tākoutou. O mā tātua waka nei e tangi atu. Engari, ka tiru atau ki tērā taha o i taku hoa rangatira. Nā koutou. Nā koutou. Reira. E kua ngā kau, ko whakaitia mai e koutou māku e noho i konei tēnei. Nā koutou rā, tērā take i whakarite. E hara nā ue nei. E hara nā ue nei. Nā reira, e mihi ana ki te taha i taku hoa ki te whānau pōhio rātou katoa. Rātou katoa. Nā reira, e hara me i te me he tauhau au i konei. Ko i tonu tētahi o koutou. Mō kai. Wa koutou tono. Hei aha. Hei whakapakari hoki hei tuara mō te iwi haere whakamō. Reira, e hoi nei tātou i te waka kotahi, te whai ai te kei, te huri o te kei, a nei tātou i te rangi nei. Nā reira, ka rea mō te wehe haere i ngā tangata e noho nei. Engari kotahi tonu te mihi ki a tātou katoa. Ko te taka kei mui a tātou, he take ua. E rahi, e take rahi. Ki te kore e whakaritea, ko i ka mōhio. Engari, ko te whakarite tanga o tēnei take, e tino ua, i wau nei whakaru. Reira, mana, pea, tātou katoa, e mana ki pai, e tiaki i wa tātou mahi o ngā tau, o ngā maramarane, e te heke mai. E tiko te kōrero Edward, o tāta mātou mahi, e whakarongo. E whakarongo. Ko nā mātou i mau mai ki konei tarangi nei, kia ronga aki, ki ngā kōrero, ki ngā naue, ki ngā pirangi a te iwi, ki ngā naue, ki ngā pirangi o te motu whānui, o tēnei rohe whānui tonu. Reira, Ia te mea ko tai mai mātou ko whakaiti hoki, ko whakaritea. E kao. E kao. Kia rungo rānei ki wā koutou koro kātahi anō. Ka pai te tū i te ki me pēnei, me pērā rānei. Reira, o te atu wā koe nei me i kia tātou i te rangi nei. Engari e ko ngā kau. Ko tai mai ki roto i a koutou, i taku whānui, taku whānau whānui. Kia tātou katoa koe nei, o te kau ne here kātahi anō nei ka tūtaki. Engari ko te kaupapa nāna tātou i mau i kupa nei, koene te taki, koene te kaupapa. Reira, huri no, tēnā koutou, kia ora tātou katoa. Hoki atau, kia mātātua. Te tiki atu ki taku waiata. Rungo ake au ki tō koutou waiata, me tika rā ka whātoro atu au kia te kōti. Kia rātou katoa, hei waiata mo tātou mōku mo te rangi nei. Reira, a tai hoa ke rā. Taku rā kau kau rawa ki te whare, ka ngaro atakahi te whare o te kahi katoa. Hei ngau whakapai hei whakapai urungo, hei hau mai nei, kei waho kei te moana. Ka hore aku mihi aku tangi mō koutou. Mau puku ko te iwi a mō ai tonu te whenua e tākoto nei. Nā ngā kupu o te waiata nei. I mō wai ana te whenua me te wai. Me te mōre ka haki ki te kōrero rā. Toi tū te whenua. Toi tū te wai. Patu ngaro te tāna. Reira, i runga ui rā whakaro. Papai rā te timatanga o tēnei hui. Reira, huri noa, tēnā koutou. Tēnā koutou. Yora tātou katoa. Kei rā.
Rauranga tirama, e koroma, e fuima, tēnā koutou, tēnā tātou katoa. Welcome to the commencement of these hearings into the submissions into the proposed Otago Regional Policy Statement of 2021. My name is Ron Crosby, and I've been appointed to chair the panel. And I wanted to commence by introducing the members of the panel to you. So commencing on my right-hand side, and if I can say to you that on asking for their CVs, I was staggered at the weight of degrees and the weight of experience of all of them, and I feel very whakamā, very humbled to be asked to chair a group of people who have far more experience, I think, than I probably do. But on my right is Angus Sullivan, who's a planner from Canterbury, highly experienced in hearing a whole range of plan preparation and resource consent issues. On my far left, Alan Cubitt, who I noticed, Alan, on your CV, you actually have an LLB, which I was unaware of, but to rely on that.
I don't know how to use it.
Alan's a very experienced planner as well. So the planning expertise on this panel is quite extraordinary from those two people. And I know that Ro and I will be very heavily reliant on that. You've heard our kai kōrero from in the form of Ro Kirikiri from whānau Apanui, stemming from Te Kaha, and he too drips his own different types of degrees, and and has very broad experience, having served in foreign affairs and various other public government roles in the past, and holding a number of trusted appointments over time. My background was as a barrister for about 30 odd years, and then started to write history, books on New Zealand history. We have such a small population, or I write so poorly, that you can't possibly survive on that. So I've had to continue in a role as an RMA commissioner on various planned hearings and resource consent hearings. And I also had the privilege of being on the Waitangi Tribunal for the last 10 years or so. So that gives you hopefully a bit of a summary of the people who will be hearing these submissions and the breadth of experience that we hope to be able to jointly bring to bear in making our decisions. It's going to be a long road for us. I'm from Marlborough, Ellen's from Otago, Bianca's from Canterbury, as I say, and Roe from is living in Wellington. And we all have broad experience really across the country that we hopefully can bring to bear. So against that background, can I just move with some legal issues? We obviously, as you all know, are facing an immediate dilemma in how on earth we deal with integrated management in Otago for planning, when we face, and I know criticism for a moment of the High Court judge, but we face the difficulty of having to deal with this proposed regional policy statement in terms of dealing with the non-freshwater aspects. The freshwater aspects, we are going to probably veer on the side of caution and trying to avoid anything that relates to quality or quantity that arises in terms of the statement, but it's an extremely difficult job, and we're immediately grateful to staff and to whoever has been the legal advisor for the Regional Council in terms of trying to differentiate that for the public and for us in the way in which we go about that. So if you err in terms of quantity and quality of water issues and evidence or submissions, don't be surprised if at some stage I ask you to just try and avoid that, because it is something that is going to have to await the next set of hearings by whoever might be the freshwater panel that gets appointed to hear those submissions. The next thing that I wanted to raise was just there have been some memoranda filed by Port Otago's council and by council or the council in relation to the litigation in the Supreme Court and the fact that there's a decision awaited on that very crucial word avoid. And obviously, hopefully, that comes out during the course of these hearings, that decision. We're very mindful of the fact that Port Otago and any others affected by their submissions wanting to have that opportunity of addressing us after that decision comes out, and we'll do our level best to allow that. But at some stage or other, we may just have to make the call to go ahead and hear submissions and make decisions depending on what comes out of the Supreme Court. So some machinery matters, if I can, but before I move on to those, are there any other legal issues that anybody else wanted to particularly raise, or jurisdictional issues that anybody wanted to raise? And if there's not, if I just move on to some machinery issues, the very obvious one, cell phones off, please. I noticed I have my cell phone on halfway through the by-quarter rule, which is not a good thing. But if you could ensure that they're off, thank you. The sitting times were indicated in the notice of hearing that we would be generally commencing at 9:30 and sitting, I think, till 4:30 through the weekdays. But on the last day of any particular sitting week that we are sitting, we have to finish at 12:30 for us to be able to get to Plains. So the breaks that will occur will be 15 minutes for morning and afternoon teas, 1 hour for lunch, and we'll be flexible about those, and we'll try and fit those in around council's submissions or witnesses' statements of evidence. We'll just have to see how we go about those. I've got a list here that's been given to me, and I regret for those of you who are going to be coming back repetitively that you're going to have to repeat and apologise to the panel members. You're going to have to repetitively hear these directions in terms of health and safety issues, which are the bane of the rest of our lives. To the left is our hearing administrator, Kate, who's seated behind the screen there, and she's available for any practical problems that might arise during the course of the hearing. Submitters will be asked to come forward and make presentations from the table here to the left. And I regret to say that I've been informed that council is not able to offer morning or afternoon tea facilities. There isn't the capability to do so. It would be in room accommodation terms, but water is available on a table on the foyer outside the door through which you entered, which I assume is the one back. Bathroom toilet facilities are located out of the door through which you entered, in the corridor to your left. Evacuation and emergency procedures are that if the fire alarm sounds, we're requested to leave the building immediately, use the nearest stairwell exit, don't use lifts. Nearest exit is through the doors behind you, through which you're entered and to your left, and the OIC staff will then guide you to the exit. Security doors will either become free access, or you can press a green button pad to override the lock. We're struggling with the locks, and I hope people didn't struggle on the way in. The rally point is outside the Spates Ale House, which is very appropriate. So we'll stand there until the fire warden has completed their reconciliation duties. And if there's an earthquake, they're supposed to shelter under any close by a desk until the shaking stops and wait further instructions from the fire wardens. Assistance during the hearing, if you have any needs, then as I say, Kate Kamai is the person that you will need to see. So I think that's all that we need to cover at the moment. And welcome to you all. And I think the order of the day now is that we're here opening legal submissions on behalf of the Otago Regional Council. Thank you.
Commissioners, my name's Alistair Logan. Seated to my left is Thea Sefton, my associate. We'll present opening submissions. They'll be done in two parts. I'll give a very general, well, that empties the room, a very general overview of the RPS. And Ms. Sefton will then introduce the first topic. It's on the Commissioner's agenda. I should say at this point that will be a bit of a rotating presence here from legal counsel. Not only Ms. Sefton be here at times and over there at times, but colleague Simon Anderson will also be hearing. I'm sorry, I missed the name. It will be a bit of a rotating.
Yes, I heard that, but the name of the counsel is
Simon Anderson.
Simon Anderson. Yep.
So, may it please the Commissioners that Regional Council must have a regional policy statement for the Otago region, statutory framework around which that policy statement must be prepared and adopted. Regional policy statement must achieve the purpose of the Act, that is sustainable management, defined in Section 5, by providing an overview of the resource management issues of the region, policies and methods to achieve integrated management of its natural and physical resources. Regional Council must prepare an RPS in accordance with its functions under Section 30, Part 2 of the Act. Its obligations to prepare an evaluation report in accordance with Section 32. Its obligation to have particular regard to the evaluation report, Section 32. Any national policy statement, New Zealand Coastal Policy Statement, the national planning standards, and any relevant regulations. ORC must have regard to any management plans and strategies prepared under other acts. relevant entry in the heritage list prepared by Heritage New Zealand. Heritage New Zealand by Heritage Taonga Act, regulations relating to ensuring sustainability or conservation, management or sustainability of fisheries resources, including regulations or bylaws relating to puri, pingamatai, or other non-commercial customary fishing, to the extent their contents have a bearing on the resource management of this region. Must also have regard to the extent to which the RPS needs to be consistent with the policy statements and plans of adjacent regional councils. Must have regard to the extent to which the RPS needs to be consistent with regulations made under the Exclusive Economic Zone and Continental Shelf Environmental Effects Act 2012. Must have regard to any emissions reduction plan made in accordance with Section 5ZI Climate Change Response Act, and to any national adoption plan made in accordance with Section 5ZS of the Climate Change Response Act. In addition, the council must, to the extent their contents have a bearing on the resource management issues of the region, take into account any relevant planning document recognised by an iwi authority, and there are 4 in this case, being taken into account, and we'll hear more about that in due course. And you will have read about that in some of the evidence which has been recirculated. Must also have regard to in relation to a planning instrument prepared by a customary marine title group. I can say that at the moment there is no such document that's applicable. There are proceedings in the High Court relating to applications under the Marine Maritime Coastal Area Act. Those proceedings are yet to be determined either by judgment or by agreement. Regional Council must not have regard to trade competition or the effects of trade competition. Section 62 stipulates what an RPS must contain, set that out in the written submissions, so don't propose to read through it. But I do want to highlight Section 62 subsection 3. Regional policy statement must not be inconsistent with any water conservation order and must give effect to a national policy statement, New Zealand Coastal Policy Statement on National Standard. That is an important provision in the context of this hearing. It sets out the position of an RPS in the hierarchy of planning instruments made under the RMA. The RPS must give effect to the New Zealand Coastal Policy Statement, National Planning Standards, and the following national policy statements. It's the National Policy Statement for Freshwater Management 2020, the National Policy Statement on Electricity Transmission, National Policy Statement for Renewable Electricity Generation, National Policy Statement for Urban Development, and the National Policy Statement for Highly Productive Land. National Policy Statement on Urban Development was updated on 11th May 2022. National Policy Statement for Highly Productive Land was consented in 2022 and came into effect on 17 October. Ms. Boyd has addressed the effects of that National Policy Statement on submissions and supplementary evidence dated 21 October 2022. Further, the National Policy Statement for Freshwater Management was updated on 8 December 2022 and the amendments came into effect on the 5th of January this year. Those amendments broadly address the management of wetlands, clarified the scope of take limits as defined by the SFM, make provision for attributes affected by nutrients, introduce new principles for aquatic offsetting and aquatic compensation, and make minor drafting changes. For the purpose of this hearing, that's the non-freshwater parts of the RPS, the most significant amendments relate to wetlands and include removal of the definition of natural wetland, replacing the definition of natural inland wetland, additional exceptions to the requirement to avoid the loss and extent of the river and extent and values of rivers wetlands, and new principles for aquatic offsetting and aquatic compensation. These matters and their implication for the panel in making recommendations on submissions would be covered by Ms. Boyd in additional supplementary evidence. That evidence would be relevant to the land and freshwater section of this hearing. The panel may wish to timetable the lodging of Ms. Boyd's further evidence and any evidence from the submitters on these amendments in response.
Have you got any suggestions in that regard, Mr. Logan?
Well, I believe that could I confer with Ms. Boyd about the?
Yeah, I mean, I don't want to be unreasonable.
Take her to address those.
I don't want to be unreasonable on her, but I imagine too that whatever she says might, other submitters might want to comment on.
Yes, I anticipate she would go first,
Mm.
Mr. Chair, and that other submitters would have the opportunity then of responding.
Yeah, good.
And that can be done before the land and freshwater section of this hearing is reached, which is some distance down the track.
Right. Yeah, possibly by the end of lunch, the lunch break, if you could come back with some indicative dates.
Yes, I'd like just to confer with her on precisely when she can do that, bearing in mind that she has other commitments in this hearing this week. And I don't want to put her in a position where she's under undue pressure.
No, nor do I, but clearly that's going to be important for us and important for other submitters potentially.
Yes, I agree. It should be dealt with up front, and the process which you've outlined is the appropriate one to follow.
Good, thanks. Paragraph 15.
Yes. So how does these changes in national direction fit in with this process on the post RPS? Well, that was notified way back on 26 June 2021, with submissions closed on 3 September 2021. Changes can be made to the proposed RPS to give effect to amendments to the national policy instruments and to give effect to the new national policy statement on highly productive land, only to the extent that the amendments are within the scope of submissions received on the proposed RPS. Turn then to the proposed national policy statement for Indigenous biodiversity. An exposure draft was released for comment in June 2022. The Ministry for the Environment's website anticipated that the NPS would be gazetted in December 2022. Wasn't. Web page now predicts gazettal during 2023. Nothing more precise than that. Proposed national policy statement, Indigenous biodiversity, has no legal standing. There's no statutory direction to give effect to it. The national policy statement for Indigenous biodiversity may not be issued in terms of the exposure draft or any earlier iteration. Commissioners may be aware that there's been talk of the national policy statement on Indigenous biodiversity for 10, 15 years. And nothing has even materialised. Put it this way, the horse has come close to the drinking pond several times, but never dipped into it. So there is no certainty around that, and we've got to proceed at this stage on the basis that there is no national policy statement in place. If, however, a national policy statement for Indigenous biodiversity is issued before the panel reports to Council with its recommendations, then it will be necessary for the panel to consider how to respond. Provision will need to be made for additional legal submissions and further evidence, particularly from ecological and planning witnesses. So that's a bridge we'll have to cross if and when we reach it. Port Otago, before we alluded to that, Mr. Chairman, has alerted the commissioners to the consideration by the Supreme Court of port-related issues arising out of the partially operative RPS 2019. That hearing was consolidated part with the hearings of submissions from parties engaged in litigation arising out of the resource consent applications and notices of requirements sought by Waka proposed east-west link in Auckland. The hearing concluded in May 2022. Judgment was reserved. The court has not given any indication when a decision will be released. The judgment will necessarily have implications for Port Otago's submissions on this proposed RPS. It may have wider implications impacting on other matters which the panel has to consider. And I say that because the way in which the court consolidated the two hearings suggests that much wider considerations may be in the minds of the members of the court and be the subject of judgment. If a decision is released before the commissioners conclude their task, it will be necessary to take stock of how to give effect to that decision. Input will need to be sought from participants in this process on the procedure which should be followed. It's likely that legal submissions from interested parties should be sought. It may also be necessary to allow parties to present additional evidence. At this stage, the possibility of the decision intervening in the process can only be noted. RPS forms part of the cascade of planning instruments from the national to the local. It sits at an intermediate level. Regional and district plans are subordinate and must give effect to the RPS. Rules allowing, controlling or prohibited activities are found in plans. The RPS may nonetheless contain policies which in practical terms have the effect of rules. The significance of our RPS is not confined to the contents of subordinate planning instruments. Proposed or offered RPS is a relevant consideration in determining a resource consent application or a requirement for designation. I want to turn to now to the point which you, Mr. Chair, raised right at the outset of the difficulty of this process as a result of the division of the proposed RPS into two parts. Freshwater as a freshwater planning instrument in part and as a non-freshwater planning instrument in part. So this process which we have commenced this morning is confined to hearing and making recommendations on submissions relating to the non-freshwater components of the proposed RPS. Despite the statutory requirement for an RPS to provide for the integrated management of the region's natural and physical resources, the proposed RPS has been, we've noted, split into two parts. The proposed RPS was originally notified as a single document constituting a freshwater planning instrument under section 88 of the RMA. The classification was challenged. In light of those challenges, ORC instituted proceedings for declaration in the High Court to determine whether the notified proposed RPS was, as a matter of law, a freshwater planning instrument in its entirety. The High Court held that it was not, and the court made three declarations. I've set out in paragraphs 24. Don't think I need to read them. Present purposes. The judgment held that parts of the proposed RPS would only form part of a freshwater planning instrument under section 80A if they directly relate to the maintenance or enhancement of the quality or quantity of fresh water. The court found there were two ways in which provisions might qualify as part of a freshwater planning instrument. They may give effect to the provisions in the National Policy Statement for Freshwater Management, which directly relate to the maintenance or enhancement of freshwater quality or quantity, or provisions in the proposed RPS might otherwise directly relate to the maintenance or enhancement of freshwater quantity or quality. Evaluation was carried out by the council. Provisions constituted a freshwater planning instrument were identified. In accordance with the High Court judgment, those provisions were re-notified as forming a freshwater planning instrument. The freshwater part of the proposed RPS will progress through a separate freshwater planning process. Because the present process is confined to hearing submissions on the non-freshwater part of the proposed RPS, the council can only grant relief on submissions, grant relief founded on a submission within the scope created by the original submission and the non-freshwater provision or provisions to which the submission relates. If the original submission relates to a provision which is now in the freshwater planning instrument, then it is outside the scope of this hearing. Dual processes are not ideal. Goal integrated management is at risk. There are connections between and overlaps in subject matter, evidence, and no doubt legal submissions. It's therefore therefore important that at a practical level the two processes unfold in parallel and talk to one another. Otherwise, there's a risk of inconsistent and conflicting outcomes. Each panel should be able to keep an eye on what the other is doing. The problem is how to achieve that. The suggestion that we make is that after the programmed hearing, the non-freshwater part of the RPS is finished, the panel may adjourn the hearing and delay its recommendations to council until the freshwater panel has completed its hearing and made its recommendations. In that way, the two separate processed parts of the RPS might be brought seamlessly together.
Can I just ask you, on your perception, is there any statutory mechanism of enabling the two panels to talk to each other, as you've mentioned?
There's no statutory mechanism. I was using talk to each other as being in a rather metaphorical rather than physical sense.
Right.
And the way in which I suggested that might be achieved is to see what the outcome is from the freshwater hearing panels process and look at whether the tentative recommendations that you have reached need to be adjusted to enable the document to be brought together as a whole.
To do that, you'd really almost have to have a release of a tentative decision, would you not, by each panel for the other to take into account?
Well, that might be one way of this panel achieving the task. And then the freshwater hearings panel could bear that in mind. Equally, I suppose, although there's no statutory provision enabling the freshwater hearings panel to issue a tentative decision, I would expect that's implicit within its processes that it could do so.
Yeah, thank you.
So
You're going to have to think about it.
yes, but I think there's no legal impediment to what suggested, Mr. Chair.
Thanks, Mr. Logan. Your comments have been are a good trigger to thinking about how that might be integrated.
I guess thinking about it a little further, as you're first out of the blocks, as it were, that's you could initiate that process by putting out your tentative recommendations that would then be before the freshwater hearings panel as it takes its task. Would it then be necessary for the freshwater hearings panel to reciprocate? I don't know, but that call could be made by at the time. So now we'll turn to the question of why we got in new RPS. The reason I pose that question is that TOGA has a partially operative RPS made operative in 2019. And the only outstanding provision that documented in relation to port activities in and around Otago Harbour, which is the subject of the Supreme Court hearing. So it might seem surprising that with the ink barely dry, ORC is embarking on the adoption of the new RPS. But in fact, there are several reasons. In 2019, and since several things have occurred to warrant replacement. The Minister for the Environment in 2019 appointed Professor Skelton, former Environment Court judge, to investigate whether the ORC was adequately carrying out its functions under Section 30, subsection 1 of the RMA in relation to freshwater management and the allocation of water resources. In his report, Professor Skelton proposed that ORC take all necessary steps to develop a fit-for-purpose freshwater management planning regime that gives effect to the relevant national instruments and sets a coherent framework for assessing all consent applications. Yes, Skelton recommended ORC begin with a complete review of the RPS in 2019. The Minister for the Environment adopted Professor Skelton's report and duly made that recommendation to ORC, which accepted the recommendation and has proceeded accordingly. In addition, new national directions come with pORPS. These include the National Planning Standards 2019, which the RPS require the RPS to be in a form that complies with standards. Initially, that was by 2022, but later extended to 2024. It's extremely difficult to rework an existing planning instrument into the mould specified by the National Planning Standards. Following Professor Skelton's report, the policy statement for freshwater management was placed in 2020, and a new national policy statement for urban development was issued in 2020 as well. Both of these new directions were materially different from their predecessors. 2019 RPS could not and did not give effect to them. So for these reasons, ORC has developed and is promoting a new RPS. The review was commenced by ORC's elected members, identifying 9 relevant regional issues. They were natural hazards, climate change and its impacts on the economy and the environment, pest species threatening indigenous biodiversity, economic activities and landscapes, the impact of urban growth on productive land, natural assets, infrastructure and community wellbeing, water demand exceeding capacity in some places, Otago's coast being a rich natural, cultural and economic resource but facing threats from a range of terrestrial and marine activities. Lakes Wanaka, Wakatipu, Awea and Dunstan attracting visitors and new residents, putting pressure on the unique environment. Economic and domestic activities using natural resources but not always properly accounting for environmental stresses and future effects. And the environmental costs of activities stacking up and may soon reach a tipping point. Public consultation confirmed the importance of these issues to the regional community. As a result of feedback during this consultation exercise, 2 more issues were added: improving water quality and protecting biodiversity. A broad section of people contributed to the development of the RPS issues through a variety of means, including in-person public workshops and online surveys. The issues having been defined, 11 reference groups were established to assist in developing policy addressing each of the issues. A draft RPS was prepared, was distributed to stakeholders and reference group members, including Kaitahi. Feedback from 42 persons was received, taken into account in revisions to the draft RPS. The Otago Regional is within the Tahu Whanui Takawahi. ORC is actively engaged with iwi in developing the proposed RPS. This engagement has been principally through Okaha's representing before Papatu Wanaka Kaitahi Otago. Te Marama is representing before Papatu Wananga. Kaitahi involvement has included reviewing and providing advice on the draft policy direction papers prepared for the reference group, participation in drafting and revising the resource management issues of significance for iwi, the Mana Whenua chapter and the historical and cultural values chapter. Engagement in the statutory consultation on the whole of the proposed RPS is required by clauses 3, 1 of the RMA, and taking into account the relevant Kaitahi resource management plans. Resource management partnership with Kaitahi is fundamental to the proposed RPS, and that is set out in the objective 1 of the Mana Whenua chapter, the heading principles of the Te Tiri of Waitangi. Kaitahi's participation in the preparation of the proposed policy statement does not, of course, limit its ability to make submissions and seek revisions to the proposed document. A key feature that has emerged through the various consultation exercises was a desire by participants to protect the environment and a possible remedy environmental harm where that has occurred. The essence of the community's sentiment is captured by the long-term vision, which I've set out at paragraph 58, and which is also the first objective in the integrated management chapter. Forward to the proposed RPS explains that the statement reflects that a healthy, flourishing environment is fundamental to our well-being. Integration is the central tenet. Seeing the environment as a single connected system, tie and weaving this into the RPS fabric. Those aspirations underpin the proposed RPS. A healthy environment is fundamental to provide for the social, economic and cultural well-being of people and communities. Activities can occur, but within the constraints set by the proposed RPS. In other words, people are free to undertake activities which yield social, cultural and economic benefits, but not at any cost. The proposed RPS is directive and restrictive where it is necessary to protect the environment and restorative where damage has occurred. As examples, the region's outstanding landscapes, natural features and water bodies are protected. Steps to be taken to improve air quality and polluted airsheds. Biodiversity losses to be prevented and significant areas protected. This underlying philosophy is the touchstone for the panel in considering submissions and making recommendations. The proposed RPS is not singled out as a general rule and made distinctive provision for particular activities, except where required by a national policy statement. So, for example, there are not distinct provisions for mining or other extractive industries, nor for food and fibre production. Policy statement structured on an activity-by-activity basis is difficult to reconcile with the national planning standards, would be unduly complex, lose integration, and dilute the core principles which the RPS seeks to establish uniformly across the region. As noted, the purpose of an RPS is to achieve integrated management of natural and physical resources across the region. The RPS must cover a diverse range of domains and topics. Further, the RPS must comply with the national planning standards. The standards tend to force provisions into silos. Accordingly, in this proposed RPS, the integrated management chapter performs an important function. It brings the threads together. Its objectives set out the outcomes sought by this RPS. Set those out at paragraph 69. And this is the 31 October 2022 version of the proposed RPS, which takes into account the amendments suggested by the various report writers as a result of their consideration of submissions and subsequent discussions with submitters. The rationale for those changes is explained in both the section 42A reports and in supplementary evidence. Paragraph 70, I set out first policy IM1 from the integrated management chapter, which explains how the various provisions of the RPS work to be brought together in decision making under the RPS, both in support of plan making, consent for decision making, and consideration of notices of requirement. This interpretation provision reflects the environmental philosophy that underpins the RPS. The objectives are to be achieved by policies which require a holistic approach to the use and development of resources, limit human impacts on the environment. In terms of issues, Ms. Boyd will present an outline of the unresolved planning issues on Wednesday. These submissions are really no more than an introduction to the RPS in the position which RRC has adopted on the proposed instrument. An overview of the legal matters relevant to the panel's task. Council will present more detailed submissions where necessary in the opening for each subsequent topic. They do not address in detail the extensive written submissions, nor the written evidence which has been lodged by submitters. That is a matter for reply once the submitters are presented, and their cases are being brought into focus with the assistance of legal submissions.
Thank you, Mr. Logan.
That completes my introduction. Really question any
Yeah, can I just take you back to that paragraph 33 again, and not the issue of trying to link in the two processes. Are you able to inform us of any time limitations that we might be infringing by adopting that suggestion of delaying recommendations to council? And I'm meaning in that regard, either in terms of council's preparation of its land and water plan, or in terms of any broader time considerations in that regard.
There is a statutory obligation on the council to make decisions on submissions within 2 years of notification. There is provision for schedule the RMA to have that time extended by an application to the Minister of the Environment.
That's in Schedule 1.
Sorry?
That's in Schedule 1.
Yes, yes.
Yeah.
It's inevitable that such an application is going to have to be made because of delays in getting to the start of this hearing. Largely as a result of the question about whether the document as a whole is a freshwater planning instrument or not. So an extension of time is necessary and will be sought. And the period sought will try to anticipate length of time this hearing process take through to completion. At the moment, the freshwater planning process is at a relatively early stage, and that hasn't gone to the Chief Freshwater Commissioner yet. A panel has been appointed, procedural timetabling directions issued.
So when do you anticipate that that process will go to the Chief Freshwater Commissioner?
Could I come back to you about that, because I'm just not sure exactly when that might now be.
So you can come back after lunch about
Yes,
that.
but it will be during the life of this hearing.
Right.
But then that panel has to set its own timetable, issue directions and hearings. As it stands, the freshwater planning instrument is a relatively skinny document that suggests that the extent of submissions and the length of hearings required might be relatively compressed. So we're in the position where extension time will be sought. The length of time is still under consideration, needs an approval from the Minister of the Environment. One would hope that that approval will be granted. View of the history that brought us to this point, and can only continue to update new commissioners as matters unfold.
Right. Thank you.
I think there was a second limit to your question.
No, well, I think you covered it, because I was going to go on and ask you what stage you were at with the Chief Freshwater Commissioner. I think you covered that in the response that you've given. No, thank you. Are there any other matters? Yes.
I have some, Mr. Chair. Morning, Mr. Logan. Just in terms of your references to the proposed regional policy statement in your submissions, they're not the notified provisions, are they?
No, as I explained, I think at one point,
Yeah.
the 31 October 2022 version, which takes into account amendments promoted by the Section 32A
Yeah, okay. So,
writers, and then subsequent changes which are shown were applicable in red. It was sought or adopted and supplementary evidence
So
following
that-
discussions with submitters.
Yeah, okay, so, but no decisions have been made on that particular, those provisions, that's what the panel's here to actually do, isn't it?
Correct.
Just in your paragraph 65, and this is where you refer to things such as mining, food and fibre production, and reasons why that hasn't been addressed as an issue. We do have quite a few submissions on those issues, and they're pretty fundamental to health and wellbeing. I'm just trying to work out in terms of some of the issues there, particularly around national planning standards, what there is actually stopping those being identified as an issue, if we were of a mind. Was that more for planning witnesses because surely it wouldn't be impossible?
It's challenging. The national planning standard difficult to work with, at least from a legal perspective.
Yeah.
Planners may have a different view. But I think the substance of your question is probably better direct to planning witnesses such as.
From a general perspective, if you have what this document is about, specific issues facing resource management in Otago. So some of those particular things have been raised that have different issues applying to them than your normal resources. Surely that's something we could give consideration to. So it's not a generic document, there must be specific issues we can address.
Well, it's certainly open to you to address them as a result of the submissions which have been received. I haven't made an exhaustive list of them, but two that stand out are food and
Yeah, they are the two
production
that do
mining
stand
and
out.
extraction industries. There are similar cases made by Transsouth, the National Grid, and the electricity generators. But in both cases, they're leveraging off national policy statement.
Yeah.
And an attempt has been made by the authors of the infrastructure provisions to try to accommodate those.
Yeah. Okay. The only other thing I had was just in terms of a couple of the matters that you raised that are probably going to crop up during this process, the MPS for the biodiversity and the Port Otago issue raised. And you talk about obviously the need for legal submissions, further legal submissions and evidence. Will there be an issue there though? Will parts have to be re-notified, or will there be scope within this process not to go to that extent?
I don't want to get ahead of myself because we don't know what
No.
either the Supreme Court's going to
Is
say or
that
what
a
the national
possibility,
policy
or-
statement is, but there are submissions well, obviously Port Otago
Yeah, that's probably
which
less
is going to
one.
be directly affected
Yeah.
by the Supreme Court decision. One with the other. The Supreme Court decision may well, there are various ways in which you might approach the RMA, but it might elaborate on King Salmon, for example, which would have implications for other submissions in this process. It may wind back King Salmon in some ways because that's part of the argument that's presented in the court during the May hearing. And that would have implications for a range of submissions in this process. I think it's probably got to flag that with those commissioners at this stage, and if when the decision comes out, we've got to do a bit of a stock take on what that means for this process and how wide-ranging effects are on this process.
So no, I was
Sorry, Ben.
just going to say we do have evidence suggesting that we should treat the national policy statement for Indigenous biodiversity as best practice for Indigenous biodiversity management at a national level. We've got evidence suggesting that. I mean, I'm assuming we would have to be looking at evidence to support that before coming to such a conclusion. Would you agree?
Yes, I'd agree with that. It's not that you can take it, it must give effect to it. But the draft, I suppose, to the extent that some witnesses rely on it as part of the evidence which goes into the mix, once you make your recommendations on biodiversity and ecological issues. But there's also, as I understand it, some competing evidence doesn't accept some propositions. So that gives you something of a license to reach your own views, whereas if the NPS was in place, the document which you had effect wouldn't be that freedom.
No, I think so. I think so.
On pages 12 and 13, you outline the extent to which Kaitahi has been involved in this exercise at the moment, including the work that Taukara and Taumarama have done. But I just wondered whether there are any other legal impediments or things that we need to be aware of in the context of what the Kaitahu submissions and expert evidence has given us so far. I mean, should we be alert to any particular things that from your legal standpoint are going to be particularly challenging, for example?
I'm not aware of any legal impediments to the case which is going to be presented by Tahu shortly. I've the opportunity of reading in advance Mr. Cameron's submissions, and I'm broadly in agreement with what he is going to say to you.
Yeah.
So that there's nothing that I've particularly wished to raise. Ms. Sefton will give a brief introduction to that aspect of the hearing shortly. But I don't anticipate there's anything in her submissions raising legal problems for you, considering the case.
I'm thinking in particular of some of the submissions that we've received around some of the historical and traditional ways in which these issues have been dealt with in the past, from a Kaitahu perspective in particular. And what seems to be coming through fairly loudly and clearly about the desire to be even more closely involved moving forward. And that's pretty obvious. And in that regard, I can't help wondering whether there are some underlying or underscoring issues here that I know the Section 42 report brought up a whole lot of stuff there, and for the most part, that's been kind of left because it's too hard. That's what it sounded like. That's what it felt like, that we needed to keep coming back to Ngaito and maybe to the panel to reach some sort of conclusion or decision. But I one can't help wondering whether there are some more underlying, maybe even, they're not necessarily legal issues, but there may be constitutional or whatever stuff that has made the sort of smooth transition not so smooth in the past, but looks like it's become smoother.
Well, I'm not aware of any legal or constitutional impediments. I see some the extract which is on page 13 confirms the OSC's perspective, one working in resource management and partnership with Kaitahu. I've signalled in written submissions. It doesn't necessarily mean that the document is entirely right from that perspective at this stage, and RC's is open to changes which meet Kaitahu's aspirations within the framework.
Okay, thanks very much.
I've just got a few final issues that I'm not sure whether I should address them to you, Mr. Logan, or to myself in terms of the mana whenua, some of the mana whenua recommendations and legal aspects that arise out of that. Is it something I should raise with you?
Raise them with me in the first instance, and
You can-
pass the ball.
Exactly. Yeah. Well, look, the first one probably arises out of MWP2, the treaty principles, and the recommendation made at page 46 of the chapter 4 report that a submission or that an outcome is that the wording will be local authorities exercise their functions and powers in accordance with the principles of the Tariki or Waitangi, and then 2, including Kaito in resource management processes, implementation and decision-making to the extent desired by mana whenua. And I'm very cognizant from another hat in terms of the Waitangi tribunal processes, etc., of and it becomes very clear too from the Kaitahu evidence that we've received here of the call for iwi hapu to be involved in or have an involvement in the management of their resources as a treaty partner. So that's, if you like, one of the principles that needs to be taken into account. But equally, if you start looking particularly at the method that flows from that, which is probably best to take you to the page number on that report, which is at page 61, and the method, which is MWM4, that is in the plan, in the policy statement rather at the present time, is local authorities must facilitate Kaitahu involvement in resource management, including decision-making by 1, including accredited Kaitahu commissioners on hearing panels for resource consent applications, notices of requirement, plan changes or plans where Kaitahu values may be affected. And when you read that wording, the other more general principle of law in terms of natural justice from the Nemo, Judax and Suakaza principle applies. And where do we strike the balance between those two? The desire in a treaty sense for a Ngāi to have an involvement in decision making in relation to their resources, and the potentially conflicting natural justice requirement that someone is not set up to be a judge in his or her own cause. Are you able to assist us with that dilemma?
I understand the point you're making. Rather give that some consideration.
Yeah, look, I'm happy for you to do that, and because it is a significant and important issue in both of those respects, and somehow we've got to try and work out an outcome that works for both issues of concern. So, and as far as I'm concerned, and I'm not sure about the other members of the panel because I haven't discussed this in detail with them, but if you wanted to leave that to a reply at the end, that's fine. Need that legal input from the council as to how it, in a legal sense, sees how you resolve that tension.
Yes, I'll take that opportunity and maybe
Thank
as
you.
best as you suggest, Mr. Chair, to deal with that and
Right.
reply.
And the next issue is of a legal nature that related to the definition of Māori land that has been finally recommended to us. And again, I'm just trying to, probably best if you look, if I took you to page 13 of Mr. Adams' supplementary brief of evidence. And at page 13, paragraph 41 in red is his, what in essence he recommends, and it ends up with particularly two subclauses that I wanted to ask you about. The first being that for the purposes of the Otago RPS, Māori land, I'm interpolating, Māori land means land within the region, that is, and then 6, held or claimed by Te Rūnanga or Ngāi Tahu and or related entities, including by a person or persons with a whakapapa connection to Kaitahu, where the land was transferred or vested, is, and the English doesn't read well at the moment, is an entitlement or as part of an ancillary claim, A, as part of redress for settlement of Treaty Waitangi claims, or B, by the exercise of rights under a Treaty Settlement Act or a Treaty Settlement Deed, as those terms are defined under the Urban Development Act 2020. So that's one classification that's recommended to be added. And then the last one is 7, owned by a person or persons with evidence of Kaitahu whakapapa connection to the land, where documentary evidence of whakapapa connection is provided from either the Māori Land Court or the Te Rūnanga or Ngāi Tahu whakapapa unit. And I just wanted to raise the question as to, it would seem to me that it would have been easier to have simply said any land, Māori land, because it's all ancestral Kaitahu land in this region. Anybody with a Kaitahu whakapapa who acquires land would appear to be able to argue that that was Māori land, on connotation of whatever might be the provisions that flow from that. Do so. In other words, am I reading it too broadly in saying that in reality, if you look at what was the ancestral position, it means that the definition of Māori land that we're being asked to or recommended to adopt is a recommendation that in reality means all land.
Yes, I see your point, Mr. Chair. I'm not sure that that was what was intended, but there is evidence about the definition of Māori land from a number of witnesses, including, remember, Mr. Adams, the report writer, Ms. McIntyre, and parties, and I think Ms. Kane.
Yes.
And it would be useful to hear from them because these additions to the definition emerged from discussions which Mr. Adams had with these parties, and I think the commissioners would benefit from an understanding why they sought those amendments. And indeed, I think others changes are being sought through this hearing. So
I think Mr. McIntyre's goes further.
there's an evidential context that needs to be teased
Explored.
out.
Yeah. All right. No, thank you for that. And thank you for the general overview. Just in terms of just going back again for a moment to that issue of freshwater process and this process, where would that, in a statutory sense, where are the limitations that we might face in terms of our recommendation process or the recommendation procedure to the council? Is there any problem that arises out of that?
Not that I'm aware of. No.
Right. Thank you, Mr. Logan. Yeah, sorry.
Ask one more question, sorry, Logan, on the same method for, and it's number 2, it's about the resourcing. So this is a must facilitate and is a well-practiced local authority solicitor, you might understand more about how funding is determined. Is it legally possible to have a phrase like that in a method like this, requiring a council to do that when that's a separate sort of process you have to go through, how you set your rates and what they're set for?
There are various instruments which impose legal obligations on local authorities, which they must discharge and need to go through a process of identifying the sources of funding for those on an annual basis.
Yeah.
Whether it's an annual plan or long-term plan situation. So I don't think there's a suggesting there's a virus issue on it. I don't think there is. Just,
In reality, how they may not be able to give effect to it if it is challenged throughout the plan process, or just thinking aloud.
Just to add to Mr. Cubitt's point, Mr. Logan, I think really goes back to the use of the word must. Local authorities must facilitate NITO involvement by resourcing. And so I think really the point Mr. Cubitt is raising is it possible for an RPS to, as a mandatory matter, require resourcing?
And it's an ideal that may not be given effect to by any local authority, by certain local authorities.
Well, my immediate reaction, and I might want to take the opportunity of reflecting on this a little further, is that an RPS is a document which territorial authorities, regional council itself must give effect to in its own regional district plans.
That's not a district plan issue.
Yes.
That's the point I'm trying to make. It's actually a finance creating issue.
Yes, it's perhaps a little bit more complicated than the first thought. That can I reflect on that? And,
If you could, and I think it would be helpful for Mr. Adams for you to have a talk with him once you have that reflection, because when you turn the page to to paragraph 212, when I was reading that, I wondered why it was that Waitaki's submission was recommended to be rejected, when in fact the following 2 lines appear on the face of it to give reasons why it should have actually been accepted. In other words, this is an operational matter better suited to long-term and annual plans. So if you could give it some thought and have discussion with Mr. Adams, so that we're not putting to him legal issues without him being at least somewhat briefed by yourself, would be helpful. Thank you.
okay.
And I think that's all the questions the panel has for you at the moment, Mr. Logan. Thank you. Secondly.
May it please the Commissioners, so this section of the hearing addresses NW Mana Whenua, which is Chapter 4 of Part 1 of the Otago Regional Policy Statement, which I will refer to as the pORPS. and RMIA, resource management issues of significance to iwi authorities in the region. And that is a section of Chapter 5 of Part 2 of pORPS. So you've heard from my colleague, Mr. Logan, and this will probably be laboured throughout these hearings. The function of a regional policy statement is to achieve the purpose of the Act by providing an overview of the resource management issues of the region and policies and methods to achieve integrated management of natural and physical resources. A regional policy statement must state the resource management issues of significance to iwi authorities in the region, in recognition of and provision for the relationship of Māori with their culture and traditions, with their ancestral lands, waters, sites, waitapu, and other taonga is a matter of national importance. And I think it's worth noting here that unlike many other matters of national importance in Section 6, recognition of and provision for such relationships is not subject to any qualifiers. And I've referenced Section 6E there and the case discussion in Royal Forest and Bird Protection Society and WA Habgood, because we've just had the discussion about the definition of Māori land. And that section and that discussion is also relevant to that definition. It remains good law, and it states, what is said to be of national importance under Section 3, and that's the predecessor to Section 6 in the Town and Country Planning Act, is the relationship of Māori people with their ancestral land, the culture of Māori people with their ancestral land, and the traditions of Māori people with their ancestral land. Under this subparagraph, it is no more a matter of considering the Māori culture and traditions in isolation than it is a matter of considering the land in isolation. There must be some factor or nexus between the culture and traditions and the land which affects the relationship of the Māori people to the land. Clearly, continuous ownership of the land by Māori would often be a relevant factor in that relationship. Likewise, it may be an important factor to consider the extent to which a special relationship by Māori has been claimed or recognised by them throughout the generations. More importantly, the effect of the proposed use of the land on that relationship will have to be considered in each case. These instances are clearly not intended to be exhaustive. I can see no logical or legal reason why Section 3(1)G of the Act should be of no application solely because the land in question is no longer owned by Māori. The general purpose of the legislature, and including paragraph G in Section 131, was to require the tribunal and others affected with town planning principles to have regard as a matter of national importance and in relation to town planning in particular, to recognise and provide for the relationship of Māori and their cultural and traditions with the land that was once theirs. Parliament put no limitations on the extent or nature of this relationship to the land, and there is no justification or judicial limitation being imposed. Now, another matter of national importance under Section 6 is the protection of protected customary rights. They are to be recognised and provided for. And in this context, protected customary rights is defined in the Marine and Coastal Area Whakataonga Act as being an activity, use or practice established by an applicant group in accordance with subpart 2 of part 3, and either recognised by a protected customary rights order or agreement. It's just worth noting there that at present there are no protected customary rights in this context in the Otago region. There are proceedings in the High Court that are yet to be determined. Particular regard must be given to kaitiakitanga in exercising powers and functions under the RMA, and the principles of ki tiriti o Waitangi must be taken into account. The principles of ki tiriti most relevant to the development of this regional policy statement are partnership, recognition of rangatiratanga, and active protection of mana whenua interests. National direction is provided with respect to iwi engagement, involvement, and collaboration. Now, the national planning standards require a regional policy statement to be prepared in accordance with it and to give effect to it. They require a nationally consistent structure, and in particular, a regional policy statement must comply with Table 2 of the planning standards. Both RMIA and mana whenua chapters are mandatory under the national planning standards. Carrying on with the partnership discussion, regional councils must and do work in partnership with local iwi in carrying out their functions under the RMA. ORC's value of and commitment to its partnership is encapsulated in the Memorandum of Understanding and Protocol for Effective Communication and Liaison, which was entered into by ORC, Te Runanga o Ngāi Tahu, and Kai Tahu ki Otago in 2003. The purpose of that protocol is to define the process for and facilitating iwi involvement in consultation and resource management processes and the mechanisms intended to promote and facilitate effective consultation and liaison. ORC, together with Kai Tahu, are part of Te Roku, Taio Otago, and the Manatamana Group. ORC has 2 appointed mana whenua representatives on its Strategic and Planning Committee and engage with mana whenua on various issues through consultancy groups, Akaha and Te Ao Marama Incorporated. The pORPS has been developed in partnership with Kai Tahu Whānui, his tangata whenua of Otago. Additional to community consultation undertaken by ORC, a draft of the pORPS was provided to mana whenua in April prior to its notification, followed by hui, written feedback, and co-drafting revisions to provisions. MW mana whenua chapter deals with the role of mana whenua in the region, and in particular, the integrated management of natural and physical resources. The concept of integrated management is consistent with haora and kia tu ki tai. All parts of Te Taio are interconnected and must be managed as a whole in a holistic way. RMIA, Resource Management Issues of Significance to iwi authorities in the region, contains expressions of Kai Tahu resource management concerns as identified by Kai Tahu as mana whenua. The MW and RMIA chapters set out the environmental management perspectives and values of Kai Tahu and affirm the basis for the policy framework of this pORPS. I turawhiri ko tahi mai anō te kapungatai no I te pū. From the source of the mouth of the sea, all things are joined together as one. The Section 42A report writer for these 2 topics and chapters is Mr. James Adams, who produced his reports on 27 April and 4 May 2022, respectively. Mr. Adams has also provided supplementary evidence dated 11 October 2022, and the ORC calls James Adams.
Panel has no questions for Mr.
Mr. Chairman, Anderson for Port Otago. Could I just ask, are you going to be wanting to hear in respect to the Port Otago matter? You seem to be starting on the substantive parts now, and
There's certainly opportunity for you if you wanted to address us on the Port Otago matter now.
well, I just thought that it was going to be discussed. That's all. I mean,
No,
I think the panel's very cognizant of the issue, which is really what we wanted.
yes.
And it's a matter of waiting to see what happens. But the problem from Port Otago's point of view is that it depends on whether the competing provisions can be dealt with on their merits or not. And the difficulty that's been foreshadowed in terms of the issues relating to king salmon is that it really doesn't allow large infrastructure projects to proceed under the RMA, which the Supreme Court are wrestling with at the moment. I'm not sure that it doesn't really require a lot of the issues to be deferred, but the concern that I've got is that if the Supreme Court hasn't delivered its decision, then Port Otago is going to have to say, well, this is what we want, but we don't know whether we're going to get it or not unless unless the laws change. The Court of Appeal position is pretty unsatisfactory in terms of where it is, and it really arises with regard to the coastal processes section, and it's pretty much restricted to that too, I must say. And from the port's point of view, if that could be changed so that it's dealt with later in terms of the timetable, then that would give the best possible opportunity to have the Supreme Court decision before the issue arose. And I've just said it now because there's not much point in my waiting around if you didn't want to hear.
Oh, no, absolutely. And no, thank you for coming forward, Ms. Anderson. And I was rather hoping you might have taken from my comments at the start that we're very cognizant of the issue and the problem you face, and similarly that we face in trying to grapple with that. So we're anxious, if we can, to try and ensure that the Supreme Court decision is received before you present to us. So we've certainly given that indication that we want you to have that opportunity if it is possible. Thank you for raising it, because we understand the dilemma you're facing.
I think that if the rest of the coastal process evidence could be heard, I would have thought. But it would be tidier to do it all together, but it's really better for the panel as to how it does it.
And the other thing too is just not really, we can't be certain, nor can you, as to how broadly the Supreme Court decide to address the issue of how you interpret a void.
Oh, absolutely. And that it was really interesting that they joined the appeal in with the East-West Motorway appeal, which raises quite different issues in terms of where it is, including the issue of whether you can in fact compensate for breaching the policies here by remedial work elsewhere, which is part of what was being looked at there. And it's difficult. I mean, none of us know what the Supreme Court's going to do. We'll be sitting hoping. Obviously, we'll hope for particular results, but no. Well, thank you. We have a problem. I think we're just going to have to work our way through it. And I'll seek the excuse today if I could. Thank you.
Thank you, Mr. Anderson, and thank you for making the effort to come. Thank you. So,
Tēnā koutou katoa, ko Ōtipote he tūraka waiwai ko James Adams Takuikoa. Mō reira, tēnā koutou katoa. I have a short introduction here of what I consider to be the unresolved points remaining after evidence had been received and transferred. And I thought I'd like to acknowledge up front as well. I noted in the evidence from cultural witnesses in relating a lot of past injustices that have happened. In particular, I think it was Matapura Ellison who noted that that was painful to recount some of that stuff. And so I just wanted to express my gratitude for putting that forward, because that's all been very useful information for me to consider. As far, this is a little in reverse, this piece of paper I have here. I might perhaps start at the end by saying that there are a number of points raised in evidence that I was happy to accept. There were a number of corrections to matters and small clarifications that were raised, particularly in the evidence of Sandra McIntyre and Maria Bartlett, that I was happy to accept around the definition of papakaiaka and incorporating reference to Māori land in that definition, and incorporating reference to hauora in MWP3 in accordance with the reasoning in my supplementary evidence accepting the definition for that term, and removing reference to Taoka Tukuiho in MW01, MWE1, MWAER2 as indicated in my supplementary evidence, and some amendments for accuracy in Table 1, and also amendments for accuracy to the Ngāi Tahu Claims Settlement Act section in the Mana Whenua chapter. And there were also some additional changes that were raised that I would be happy to support, clarifying the scope of kaitahu relationships with Te Taio in MWP24, amending MWE1 to appropriately reflect the rakatirataka and kaitiakitaka role of kaitahu, amending MWM5 clause 3A to better provide for outcomes of aquaculture settlements, amending RMIA AAI1 and RMIA CEI5 to reference wahi tūpuna instead of cultural landscapes, and amending RMIA WTA I2 to specify physical constraints to accessing nohoaka sites. I think the main points of contention that remain are in the MW chapter, and as far as I can ascertain, I don't think there are points of contention between parties remaining in the RMIA chapter or section of that chapter. The points that remain unresolved for the Mana Whenua chapter are around the definition of Māori land. Note that this does sit within the interpretation section, but we're addressing it here as it's most pertinent to the Mana Whenua chapter. And that falls to 2 points. One, is Māori land adequately defined for use in the pORPS? Some evidence has been brought that the definition is unclear in terms of how much land it applies to and whether that is appropriate in the context of an RPS. And also how the definition can best provide flexibility for Mana Whenua to purchase additional land for purposes like expanding existing papakaika, marae and marae related activities, or to offset land lost or unusable due to alienation or the effects of natural hazards. And I think this is well explained through both the cultural and planning evidence. There's then a question, chiefly through MWP4 and MWM5, about how best to provide for use of Māori land. And the specific issues there are whether the 3 subclauses to Mana Whenua P4 should be kept or removed. I've recommended that they be removed in my supplementary evidence. And whether MWM5-2 adequately provides for the interaction between MWP4 for the use of Māori land and other provisions in the pORPS, noting that Sandra McIntyre has provided some refinements to that section, which I'm also happy to support. There was also another issue raised about whether MWM1, about identifying various elements, requires a time frame attached to it, and if so, what kind of a time frame might be appropriate. So I think that is my assessment of those unresolved points. As I've heard, there may be more, so I'm happy to answer questions.
Thank you. Before I open for questions to the panel, can I just say that we've had a preliminary discussion in terms of the public kayak definition. We're keen to hear the and think it's reasonable to hear the evidence from the tangata whenua witnesses first before we address that issue with you. So both we and you have heard their responses. So we'll defer that until the 4th day, till Thursday morning.
Sure.
So we will require you to be back, Mr. Adams, on that morning to address that issue.
No problem.
So if we start any questions with Mr. Kiriko. Thank you.
I love the way planners leave unresolved questions for other people to sort out. Yeah, I understand the difficulties, or maybe not even the difficulties, the complexities. I think this one is full of complexities rather than, I think, difficulties, because I'm under no illusion that kaita who understand what Māori land is quite clearly, their own minds. So, and as the chair has indicated, it's the sort of stuff we want to come back to on the definitions sessions on Thursday. But having said that, though, I sometimes get perplexed by Maori definitions and language and reo and stuff having to fit sort of a different paradigm. And the paradigm we're talking about here is there's a Western legal one that says, you know, we have Western rules here that says, blah, blah, blah. This is what the stuff is about. So you need to fit that in some way. I struggle with it quite a lot. And I'm kind of struggling with it now. But I'll leave you with that. I'm not necessarily looking for an answer, because you may think it's hard. You know, I'm not disagreeing with you, but I do just want to highlight the fact that these kind of issues have been around for a long time. They're not necessarily new. We do have questions coming from slightly different angles at the moment, and that's what this Maori land issue definition is. In my mind, there are other questions that people haven't raised before. They've come up now, they've cropped up, and rightly so. They've long been hidden and shouldn't have been. They should have come out a long time ago. I'm not just talking about kaitahu, this relates to every other iwi, my own iwi, it's the same. So, and it's a generic issue. And I know for sure that other iwi will be watching this hearing. They'll be aware of some of these issues here, and they'll be looking, so well, let's see how this is sorted out down there, and see whether we might not apply it into Whanau Apanui or Ngāpuhi or wherever. And having said that, I don't for 1 minute believe that whatever point we might reach in this conversation, and I use that phrase quite carefully, point we might reach, may not be a decision. We might reach a point in an ongoing conversation that we will decide, okay, we've reached this point, we may not get any further, and I rather suspect we might here. I don't want to preclude our deliberations by any means, but it highlights for me, I guess, the challenges that the RMA and the wider legal and political process has raised and has been demonstrated through the treaty claims process, settlements process, all those issues. And and I, for one, have welcomed the debate, welcomed them being raised, because I think for too long we've left them. No one wants to talk about them. Oh, it's tapu, it's too hard. Just leave it over there for the time being. So, and I'm hoping that this hearing and the conversations, discussions we'll have will help us get closer to where we need to be. And I again, it's a phrase I use quite deliberately, closer to where we need to be, because I see this exercise as being one end, bringing different points of view closer to where they need to be. whether we can resolve some of these issues entirely, that's quite a different question. But the very opportunity to be able to discuss them, to be frank and open about them it's got to be applauded. And I hope that's where we do get to. I wasn't really sitting here to ask a question. I just wanted to let you know how I felt about this, having made my initial statement about how planners are really deft at being able to push the problem onto somebody else to try and sort out. But I thank you very much, James, and having read your Section 42A report and your subsequent evidence, it just confirms in my mind the need to really come to grips with some of the key issues that you've raised. You've raised them in quite a nice way, so thank you.
Thank you.
Well, Mr. Chair, I'm not sure of my question. I think I might hold my questions into the Otahu witnesses as they relate to some of the matters, the outstanding issues that James has raised, because I think it's probably best to hear from them on those first before maybe come back to James and review. Thank you.
I could do the same. I have a number of questions, but I think it might be useful to hear from the Otahu witnesses.
Right.
You can take that approach.
I think you might have a busy Thursday morning.
That's fine.
Because I too tend to have that view, because, and no disrespect to you, but in a number of occasions through your evidence, you deferred to the Kaitohu evidence or the Kaitohu approach. And I just would rather hear that approach first before discussing with you the planning consequences that arise out of that. Thank you for the presentation this morning. We'll call you back on Thursday and there's rather more not questions to you. And if you could take the opportunity though today with Mr. Logan, I'm not sure if he's coming back today, but if you could discuss that resourcing issue so that you're also equipped to respond on that on Thursday as well. I appreciate that's not a definitions issue, but we do want to canvass that with you. Right? For sure. Thank you. So on that basis, we'll take the luncheon break now for an hour. So we'll resume at 1:20 and see how we go. Thank you very much.
Ain't got lunch. Nice. Yeah.
Because they're not supposed to, even if they got someone. Yeah, and got reading my wife's gay and it's just enfranchise their families all over again.
Yep, the price is good.
Tidy up any loose ends that we left behind. No, that's all right. That's how it's supposed to be. Right.
Right, to go with the women, their children.
Each other briefly at the airport last night, but yes.
Do you want it up in there?
Yeah, one. Can we just get one more seat on the edge of that table? You can use one of the ones that's behind you there. And then that's our 5. Yes.
We've got this going pretty small, so we can take one to the middle of the
You want this up in there? Hey Sandra, are we needed the what?
I.
Right.
Coordinate.
It's an order of address. Yeah, you lot. While we're talking,
David, what you put in here, maybe.
Are you happy with that?
Do what I'm told. I'm not worried.
Not quite. I'm last. I said I would go last.
I think that.
Yeah, come up beside me, Justin.
Yeah.
Well, in all terms, women are best.
Yeah, we're gonna do that at the start of
I heard some conversation about Wi-Fi the other day that did not include me. And I went, oh. Would not have.
Because you go without saying.
I go without saying, it's taken for granted. Like a scarf. Treat that quickly.
That's all right.
Did you?
I'm gonna,
I think we should drop it.
I'd like to know about as much as.
Good.
No,
You haven't changed it. One bit.
Thank you for knowing us.
We'll tell you afterwards.
Going to see. Finally.
Good blasting, isn't it?
Oh, sorry.
There were 2 matters that I was to come back to.
Yes, indeed.
Had a lot after the lunch break. First was how to deal with the amendments to the MPSFM. What I suppose is that Ms. Boyd lodged evidence by the 24th of February. Those submitters who wish to respond by the 31st of March.
Thank you.
We wish to deal with that point now. Or would you like to- No.
I think we'll issue.
Let's have some inquiries by other submitters as to whether that proposal is adopted.
Oh, I see. Well,
But I'll advise them that.
well, obviously the panel will
Yes.
talk about that.
Understood. And the second question related to the freshwater hearing process. Further submissions closed on the 3rd of February. Regional Council intends to lodge all their documents with the Chief Freshwater Commissioner on the 27th of February. That point, that's the Chief Freshwater Commissioner to appoint a panel and set the time.
It's a unique situation, really requires a unique response to try and achieve integrated management. The rules at the end of the day, doesn't it? I mean, it's a situation where processes really require some one-off response to try and cut away the procedural dross to enable the integrated management document to be achieved.
Yes, I think we need to some pragmatic solutions to a problem which the legislature has created.
The problem is that it's just how on earth do we issue a tentative or a disclosure document or whatever it might be that might contemplate to inform the new panel without it triggering understandable responses from the public, from the submitters, that, or, you know, we've got to protect ourselves by appealing, seeking to appeal. I think there's practical suggestions about how we could do that without triggering that type of response from submitter public.
Well, in terms of appeals, your mandate, as I understand it, is to consider submissions and then make recommendations to the council. Right. And of course, in events the council will adopt those recommendations, but the rights of appeal don't arise until the council makes that decision. All that resolution is passed, and then rights of appeal to the environment. But perhaps we would need to be alive to the possibility of some form of judicial review seeking to subvert the process prior to the recommendations being made. Because I'm aware that that sometimes has happened, and with draft reports are circulated by commissions of inquiry or other decision makers, and somebody who doesn't like the way things are going seeks to have a higher authority to intervene in the process.
Right. Because there's no practical way, given the IRA, there's no practical way really that we can quietly respond in any way really to the council without that being public information, is it?
No, that's correct.
Well, thanks for those dates, Mr. Logan. Obviously we're going to be reminded of the issue, and by the time we get to closing, we'll certainly won't be wanting to have some thoughts in mind, and we'll know a bit further where we are with the Chief Freshwater Commissioner by that stage as well.
Yes, as things evolve, the answers might become clearer.
Thank you. Thanks, Mr. Karen.
Thank you, Chair. Tēnā koutou katoa, te mea tuatai, aki mihi ki te haukaika, te runaka o tākau, ki a koe, ngāti mai aha, ki a koe, o manaaki. Mea tuarua, ki a koutou, nā kai komihana, ka nuhi ki a koutou, ki a koe, te tiamana, e nā koe. Tēnā, te mea toru, ki ngā tāngata, ko hui mai nei, ngā mihi o te tauhau pā ki a koutou, o tira, tēnā koutou katoa, ko Aidan Cameron tōku i koa, ko Aotearoa mō Kaitahu, māua ko tōku hoa Ms. Riddell. Just by way of brief introduction, I paid my respects to people of this land. Acknowledged. I left Mr. Ellison for his mihi whakatau. I acknowledged the commissioners and particularly the chair, and wished everybody within the room a very happy new year. My name is Aidan Cameron, and I am the lawyer for Kaitahu. I am a barrister practicing in Auckland, and I appear today with my friend Ms. Riddell, my instructing solicitor from Te Runanga o Ngaitahu. I should just check that people in the back of the room can hear me okay, because I'm going to be directing these submissions towards those, as Commissioner Kirikiri said, who are the kai whakarongo. Now, hopefully, the commissioners will have received written submissions that were lodged in advance, and the intent behind that was twofold. One was because of their length. I wanted to emphasise certain points and perhaps not touch so much on others. And the other was really to be a bit more flexible and responsive, and to allow you to hear more quickly from the people who I'm sure you want to hear from, the people to my left and the people in the back of the room. But on page one, and there have been copies that my learned friend can provide through the administrator. Pause while those can be passed around if needed. Mr. Chair, can I ask if the commissioners have had an opportunity to read the submissions?
Yes, we have. Thank you. And thank you for appreciating that. It's very helpful.
Okay. Sorry.
But we do need copies.
It's quite all right.
Oh.
Oh, sorry, you're almost there.
Pressing the steps.
It's better for me to look at a full page and look at that. So thinking.
May well be everyone who needs a copy. So I begin at paragraph 1 by noting that Kaitahu as mana whenua have a unique and abiding interest in the sustainable management of te taiao, the environment within the Otago region. As Edward Ellison describes, Kaitahu are dedicated to the sustainable management of resources and the achievement of sound environmental outcomes. The overarching objective of Kaitahu is to build a stronger environmental, economic, social and cultural base for their people. Mō tātou mō ka uri muki ake nei for both present and future generations. And in keeping with the introduction provided to you through the mihi whakatau, if I could tautoko the comments of Commissioner Kirikiri, I accept that the responsibility you have is a heavy one, and at times will be a difficult one. But the purpose of these introductory remarks is to cover the matters which sit at the core of the Kaitahu submission, their identity, their relationship with Te Taiao, and the history associated with that relationship. These submissions then turn to address the topics that we are discussing today, namely the MW and RMIA provisions. It's my submission that these provisions sit at the strategic or overarching level within the RPS, alongside the significant resource management issues for the region. I say that's acknowledged by their place within the document, and I say that approach is also consistent with statutory recognition of the interests of mana whenua in Te Taiao, sections 6E, 7A and 8 of the RMA, strong directions which must be borne in mind at every stage of the planning process, in accordance with the the Privy Council's decision in Maguire. And is for that reason, turning to paragraph 6 over the page, page 2, that the recommendations you make in relation to these provisions will have important flow-on effects for your consideration of other domain or topic-specific provisions later in this process. We encourage you as commissioners to carefully evaluate and place weight on the evidence of the pohuka whakaatu of Kaitahu, its expert witnesses, in arriving at your recommendations. Their cultural evidence is an expression of Kaitahu rakatirataka, which is protected through Section 6E of the Act and Article 2 of Te Tiriti, and is acknowledged through the Crown's settlement of historical treaty breaches in Te Waipo Namu. It is the Kaitahu perspective that ought to drive the issues, objectives, policies and methods in the MW and RMIA provisions, as required by those lodestars in Section 6E, 7A and 8. The provisions annexed to Appendix 1 of, that evidence from the people to my left has informed the expert planning analysis provided on behalf of Kaitahu by Ms. McIntyre, Ms. Bartlett, Mr. Bathgate and Ms. Stevens. And it is for those reasons, turning to paragraph 10, that we say provisions annexed to Appendix 1 of Ms. McIntyre's evidence are the most efficient and effective means of achieving the Act's purpose in relation to those issues. At paragraphs 11 through 18, I give a brief introduction to Kaitahu Whānui, the Kaitahu Takiwā, and the relationship of Kaitahu with the Taiao. And I don't propose to read those to you, just to note they are there. At the bottom of page 3, take you to the concept of Kiota Ki Tai, which you heard about earlier from Ms. Sefton this morning. For those who are uninitiated, Kiota Ki Tai is a resource management approach which emphasises the holistic management of integrated elements within the natural environment, demonstrated the interconnectedness of environmental systems, and forming a basic tenet of Kaitahu resource management practices and perspectives. The concept acknowledges that what occurs on land will have a direct consequence for its neighbouring rivers, lakes, and the coastal environment. And when this interconnectivity is not recognised or managed well, land-based activities can have a direct detrimental effect on those other environments, including their modi. And if I could just interpolate here, of course, one of the challenges before you, which was acknowledged earlier this morning, is how to deal with a regional policy statement that's been divided in 2 parts. There are some residual concerns on the part of Kaitahu in relation to the way in which that division has taken place, but they will be addressed at a later date. I intend during the land and freshwater provisions. I don't intend to take up the time this morning on those matters. In paragraphs 19 to 23, and this is on page 4, we briefly outline the history of the Crown Kaitahu relationship, which underpins the Kaitahu approach to its submission. It is important, this is at paragraph 19, that consideration of the Kaitahu perspective on the integrated management of natural and physical resources of the Otago region does not occur in a vacuum. It must, by necessity, take into account the position as it exists today as a result of the Crown's acknowledged historical breaches of Te Tiriti o Waitangi. It was a point I think that Commissioner Kirikiri was discussing with Mr. Adams earlier. Now, this is at paragraph 20. The contemporary relationship between the Crown and Kaitahu is defined by 3 core documents. The first being Te Tiriti, the second being the Deed of Settlement, and the third being the Settlement Act itself. If I may, I will take paragraphs 21 through 24 as read, as they really summarise points that are addressed by the witnesses beside me in their evidence, and move to paragraph 24 at the top of page 5. At paragraph 24, I referred to the Crown apology in section 6 of the Settlement Act. And if you haven't already, I implore you to read the apology in full. It carries the status of legislation and informs the purpose of the Settlement Act itself. For those unfamiliar, at paragraph 25, we note that section 6, and I've used here subsections 2, but the section itself is numbered 1 through, I think, 8 or 9, records the unconscionable and repeated breaches, that should be at paragraph 25, of te tiriti by the Crown, and it's dealing with Kaitahu and the purchases of its land, including the 8 tall trees of Te Kirimi, the claim, which include the Kemp and Otako purchases discussed in the evidence. The Crown also acknowledged that it had failed to set aside adequate lands for Kaitahu and to provide adequate economic and social resources in relation to those deeds of purchase. Section 6.3 recorded the Crown's acknowledgement that it has breached Article 2 by failing to preserve and protect Kaitahu of such use and ownership of their land and valued possessions as they wish to retain. In paragraph 27, and I note here importantly, part 7 of that section recognises Kaitahu as the tangata whenua of and as holding a rangatiratanga within the takiwā of Kaitahu whānui. We say that is important as it specifically provides that the Crown recognises rangatiratanga in fulfilment of its treaty obligations. Section 6.8 of the Settlement Act also provides that the Crown wishes to enter a new age of cooperation. In paragraphs 28 and 29, we briefly summarise the effect of the fisheries and aquaculture settlements under which Kaitahu has received redress for historical and, my submission, contemporary breaches of te tiriti. In paragraph 29, we note one point which has arisen out of the evidence of Ms. Stevens in relation to enabling the establishment of new aquaculture space. It was pleasing to hear this morning that I understand that there is alignment now between Kaitahu and the Otago Regional Council on that point. In a nutshell, the wording proposed by Kaitahu reflects the fact that you can have space allocated to you under the settlement regime, but unless there are, and unless there is a framework in the, particularly the regional coastal plan, derived down through the RPS, for allocating and enabling that space to be taken up, then the redress is more apparent than real. Over the page at paragraphs 30 to 32, page 6, we introduced the Kaitahu witnesses, many of whom will hopefully be familiar to you. They will each introduce themselves, and so I won't attempt to summarise. But over the page at paragraph 32, I want to specifically acknowledge Ms. Kane and the Kane whānau, who will be giving evidence in relation to the effects of treaty breaches on the land at Maranuku, which is near Te Kāroro at Kaka Point. In the point which is made at the end of that paragraph, Kaitahu accepts and respects the right of individuals and whānau to make their own submissions on the RPS, and will leave the Kane whānau to speak to their points. Turning to the issues, whātake, that have arisen out of the Section 42A reports and supplementary evidence, and this is starting at paragraph 33. They are the proposed definition of Māori land in the interpretation section of the RPS and its importance in particular for the mana whenua policy P4 and MWM5, the use and development of Māori land and resources under P4 and M5, and the recognition of rangatiratanga and references to partnership in the MW and RMIA provisions. It's on that last of the issues that I understood Mr. Adams, in fact, perhaps both of B and C, to indicate that he agrees with the evidence. Ms. McIntyre, I'm happy to be corrected on that later. But these submissions will focus on, in particular, the definition of Māori land, as I understand it's a point that has seized your minds. At paragraphs 34 and 35, we refer to the key legal principles which you are required to apply in making your recommendations. Rather than attempt to summarise over 40 years of jurisprudence, in particular on Māori resource management issues, I have suggested that the panel, if they would like to, could find comfort in chapter 14 of the leading textbook, which is authored by His Honour Justice Fata and Paul Jury. I'm happy to make copies of that available if that would be of assistance, subject to the one caveat, which is that no one's to tell Mr. Nolan KC he may want some royalties for his retirement, and so it would be unwise for a former employee of his to dupe him out of them. Turning to the first issue, that is the proposed definition of Māori land. As Ms. McIntyre describes, the RPS as notified included provisions relating to the use of Māori land or ancestral land and kaitahu involvement in decision-making affecting such land. The notified definition was limited to land which fell within the ambit of Te Ture Whenua Māori. At paragraph 37, we set out the kaitahu position, which is developed through the pre-hearing meetings, namely a new definition of Māori land to apply to all policies relating to the use of ancestral land. This is a more inclusive definition of Māori land, extending beyond land held under Te Ture Whenua Māori to properly recognise the ancestral land base. It is also intended to provide sufficient flexibility for hapu and whānau, to meet their aspirations for reconnection to this land base and to respond to the challenges of natural hazards likely to be exacerbated by the effects of climate change. In doing so, it incorporates various categories of land that are regarded by mana whenua as having an equivalent purpose to native reserves, including land that may be purchased by Papati Purunaka in the vicinity of existing native reserves to offset land that has been lost or that they may wish to expand into. At paragraph 39, we set out the Regional Council's position, which accepts the proposed relief with two reservations, namely land owned by Te Rurunganga o Ngaitahu or its constituent Papati Purunaka, and land leased by a person or persons with evidence of kaitahu whakapapa connection to the land. And perhaps just at this juncture, I noted a point of concern about the breadth of land owned or leased by kaitahu whānau who have a whakapapa connection to the land. I've been discussing that with my client over the lunch adjournment, and there are two matters that I can hopefully help apprise you of that may assist you. So the intention behind that clause was for whānau who have a particular connection to a piece of land, who can demonstrate a whakapapa connection to that piece of land, either via the Māori Land Court, which presumably would be recorded in their status as a beneficiary, or through the kaitahu whakapapa unit. And there are established processes within kaitahu for assessing claims to whakapapa to particular pieces of land. And it is an established process, I understand, that is deployed elsewhere in district planning documents in Timaru and in Christchurch, arising out of the Christchurch replacement district plan. So there is precedent for it there. It was not the intention of the drafters of that clause to allow, for example, someone with no connection to land within the tapuā of these particular Papati Purunaka to assert an ability to rely on those clauses for their benefit. It is, I submit, intended to address a more direct whakapapa connection to that land. And I accept that is one of the complexities that Mr. Kitty has approached earlier. Over the page at paragraph 40, it's at the top of page 9, summarise Mr. Adams' reasons for those reservations, namely the very broad ambit and potential to capture within the definition of general land, land that kaitahu might purchase. And in relation to the second category, the potential uncertainty arising out of leased land In response, and I really want to make 3 points by submission. In relation to the first category, and this is it, starting at paragraph 41, the Regional Council has accepted the extension of the definition beyond land held under Te Ture Whenua Māori as appropriate, as it better recognises the historical relationship between kaitahu and these lands, including land returned through the Settlement Act. And this is particularly captured in the 4th and 7th categories in Mr. Adams' proposed definition, which is set out there at A and B below. That's why we say at paragraph 42 that any concern regarding the breadth of that particular category appears to be more apparent than real. Land that is general land can also, for the purposes of this RPS, on the existing definition, be Māori land, as recommended by Mr. Adams. The second point is to say that the proposed, in any event, the kaitahu definition, and I'm at paragraph 43 here, better implements the direction in section 6E to recognise and provide for the relationship kaitahu has with their ancestral lands. You heard earlier today from Ms. Sefton in relation to the Habgood case, and I agree with her that that case remains good law. I've also referred in my submissions to the more recent decision of Justice Bryce and Potama Kaitiaki, which related to, I understand it, the Mount Messenger bypass notice of requirement, and that decision confirmed Habgood as applying to section 6E as well. At paragraph 40, what I will say in relation to that point, of course, it is the relationship under section 6E with those lands that is protected. And that relationship is a matter of fact and degree that will vary in accordance with the circumstances. What the drafters of the RPS and Ms. McIntyre in particular have attempted to do is identify those categories of land that could fall within the definition of Māori land where the strongest connection is found. And I refer in the submissions to a case Waikato Tainui to Kohanga Nui, that's at footnote 30. That involved land at the base outside of Hamilton, land that was returned to Waikato Tainui through the Settlement Act. And the court in that case found that there was a particularly strong relationship in that case, and that required something more from the, in that case, district council in terms of its consultation requirements before it proposed a variation to amend the framework there.
Can I just ask a question here?
Yes.
Did it define more at all?
Did it define?
More, what more means?
No, it identified 2 areas of land that where potentially the relationship is the strongest, that being land which is continually held or has been continually held, and land returned under a Settlement Act. It didn't put a stop, if you like, on the other end of the relationship where that might fall into less significance. But the point of the submission is to say that there has been quite a lot of care put into that definition to identify what we say are the categories that are of the greatest importance to kaitahu. Just returning to that point about circumstances and the importance of context, we say at paragraph 45 that it is the Crown's acknowledged failure to set aside adequate lands and to provide adequate economic and social resources that really sits behind the submission and the request for a more inclusive and broader definition of Māori land than simply that held under Te Ture Whenua Māori or that which may be returned under settlement legislation. It is because the failures are directly relevant to the relationship of kaitahu with their whenua, including land which they may wish to purchase. And that's elaborated on in more detail in paragraph 46. The third point is to note at para 47 that alienation of land has been associated with a corresponding loss of opportunities for cultural use by kaitahu whānau. Mr. Matapura Ellison describes the difficulties his rinaka is experiencing in relation to Papakaika development near the coast. Mr. Tipper notes the infrastructure challenges faced by Papatipu Rinaka and the development of native reserves. These are just two examples, but they emphasize the need for a broader definition, one that provides a better ability for kaitahu to reconnect with their whenua than what was proposed, and why those two categories we say are important for inclusion. Just briefly in relation to the leasehold issue, and we address this in paragraphs 50 to 52. The short point is to say we see no reason to treat that land any differently simply on the basis of tenure. It's important to avoid a situation, and this is on top of page 11 at paragraph 52, to avoid a situation where we create anomalies that are created purely on the basis of tenure. And I've given the example of a kaitahu holder of a Crown pastoral lease, which may be on their ancestral land. And because the freehold would still be held either by LINZ or by the Crown, they would be excluded arbitrarily from this definition, where they might have a long-term lease for its use and development. And I don't see any reason why they should be excluded from being able to access the more enabling aspects of Policy 4 and Method 5. I say that inclusion of that land within the definition would better recognise and provide for their relationship with it. So in summary, in relation to the first issue, the definition of Māori land included in Ms. McIntyre's evidence is the most appropriate, efficient and effective means of implementing the strong directions in section 6E, 7A and 8 of the Act in relation to the policies that rely upon it. In relation to the particular policy and method at issue, at paragraph 54, I note that many of the submissions I've just made apply with equal force to the kaitahu submission on those provisions. Their intent is to provide clearer direction in relation to the management of Māori land, the rationale for which is set out in Ms. McIntyre's evidence at paragraphs 26 to 36. And at this juncture, I had intended to say pleasingly there is a high degree of agreement between Ms. McIntyre and Mr. Adams for ORC, particularly regarding the deletion of 3 subclauses, which acted to constrain the enabling aspects of Policy 4. On the basis, and this is at paragraph 56, that there are areas in which the Regional Council seeks to constrain use, particularly health and safety and effects on matters of national importance, are addressed elsewhere in the ORPS. Now, the submissions as filed addressed Mr. Adams's recommended pathway for kaitahu to develop their lands where there is conflict with other matters of national importance. I'm looking to Mr. Adams to say that there's alignment between him and Ms. McIntyre now on this policy, so I won't go into the same degree of depth as the written submissions do, because I take many of the points to be accepted by council. But it is simply to say that recognition of kaitahu raka and allowing kaitahu to lead in the management of any adverse effects of such use on the environment really sits at the core of what Policy 4 is about. It is saying to mana whenua, you have your land, that it is consistent with the concept of raka but also partnership, that you should take the lead in managing the adverse effects of the activities on that land, and that in doing so, you will need to demonstrate from time to time how your activity reconciles with other objectives and policies that might attempt to put into place constraints on the land. And I say that is necessary to avoid unnecessary constraints on the ability of mana whenua to make decisions about the use of their whenua, and is particularly vital where there have been historic barriers to development or underdevelopment, as at 58. in terms of how that idea or concept finds expression, and this is at paragraph 60, I say it's important not to be too prescriptive at this stage as to how conflicts with other matters of national importance are to be managed. And I refer there to the majority of the Supreme Court in King Salmon, where they said that the scheme of the Act does give you, as subordinate decision makers, considerable flexibility and scope for choice in terms of the recommendations you make. And note that it is also well established that there is no internal hierarchy as between different matters of national importance. In certain circumstances, other mandatory relevant considerations, including kaitiaki taka under section 7A and the principles of te tiriti under section 8, may carry more weight than matters of national importance over section 6. And I refer in particular there to the judgments of the High Court in Ngāti Maru and Ngāti Ruahine for that proposition. Given the potential for site-specific and or location-specific factors to influence those judgments, it's important that higher order directions do not ultimately stifle. Just quickly, at paragraphs 63 and 64, this submission was responding to the relief sought by Mr. Freeland on behalf of Dunedin City Council, which seek to reintroduce those three subclauses. And I set out there why that relief is opposed. The one point of submission I wish to make in that regard is Mr. Freeland's approach ignores the requirement under King Salmon to make a thoroughgoing attempt to reconcile policies relating to the use and development of Māori land. You need to read the regional policy statement holistically when you turn your mind to how to implement it through a district plan or how it might be considered in relation to a resource consent or a notice of requirement, and arrive at an outcome which better achieves the sustainable management purpose of the Act. What I do say is that where Māori land is involved, and for the reasons identified in the cultural evidence, it's important that P4 and M5 provide a strong signal in favour of enabling development. At paragraphs 65 and 66, or 6 through 67, we briefly respond to the evidence of Ms. McLeod. There is a planning response to that evidence, which Ms. McIntyre provide. There is also a legal response in relation to the consistency between P4 and the National Policy Statement for Electricity Transmission. Now, I intend to go through that in more detail when we turn our minds to that particular provision in the infrastructure chapters, but simply to make the point that we do at the moment that the drafting P4 is not inconsistent with and is capable of giving effect to the MPSET. Finally, and this is really the third issue, and this is an area where there is no disagreement between ourselves and the Regional Council, but where there seems to be some disagreement between in particular submitters and Kaitahu. Kaitahu made further submissions, this is paragraph 69, that made further submissions opposing relief that sought to dilute references to Lakatira Taka and Te Tiriti, and in particular the requirement in MW01 to give effect to the principles of Te Tiriti. We say at paragraph 70 that those requests have, in our submission, rightly been rejected by Mr. Adams in the section 42A report. And that's really for three key reasons. The first is that flexibility and scope for choice that I referred you to earlier, requiring the principles of Te Tiriti to be given effect to through a partnership approach is one option that's available to a regional council in preparing a regional policy statement that is consistent with the constitutional status of Te Tiriti as essential to the foundation of New Zealand and the guarantee of Lakatira Taka under Article 2. I also refer in some detail at paragraphs 73 and 74 to the Trans-Tasman Resources decision of the Supreme Court. While that decision was made under a different treaty clause, And if I can draw your attention to the top of page 15 and subparagraph A, that section begins, in order to recognise and respect the Crown's responsibility to give effect to the principles of the Treaty of Waitangi for the purposes of this Act. And that's why we say that what the ORC has done in the way it has drafted MW01 is really to reflect that constitutional norm. It does that, and it takes into account its obligations under Section 8. And I say those requirements are capable of standing side by side. The other point, which is at subparagraph C, is the court held that the way in which you frame a treaty clause doesn't take anything away from the principles themselves, doesn't oust them. They have a broader constitutional significance. So at paragraph 75, we summarise by saying that the requirement requiring those involved in resource management processes and decisions to give effect to treaty principles via a partnership approach is entirely consistent with the established approach for interpretation of treaty principles, treaty clauses, and for that matter, the principles themselves. It's the second point I wanted to make in relation to that point is one that's already been made, and that's about the internal hierarchy within sections 6 to 8 being context specific. So there will be some situations where a requirement to take into account treaty principles may override a matter of national importance in section 6 or section 7. And I think that point 2 is also consistent with the Supreme Court's decision in King Salmon, where they refer to section 8 having both substantive and procedural obligations. And that being consistent with the Crown's duty of active protection. That's a point I make at paragraph 79. At paragraphs 81 through 86, I refer to slight difference in wording between the Regional Council and Kaitahu in the evidence regarding the wording of MWE1, but I note Mr. Adams has accepted those proposed amendments, so I don't refer to them further. Briefly, by way of conclusion, at Kaitahu, this is at paragraph 88, Kaitahu looks forward to its participation in the hearings on the regional policy statement. They seek outcomes which reflect the strong directions in sections 6E, 7A and 8. The MW and RMIA provisions are of critical importance to the expression of Kaitahu Rakatirataka, Kaitiakitaka and Mana, sitting as they do at the strategic level within the internal structure of the RPS. And the combined evidence of the Kaitahu witnesses provides a compelling argument for the adoption of the amendments set out in Appendix 1 in order for the regional policy statement to fully capture Kaitahu aspirations for the future benefit of its whenua, whānau, and the region as a whole. Now, just before I open myself up to a barrage of questions, 2 points that were raised prior to the lunch agenda, which I wanted to try and front foot. And you'll forgive me while I find my references. The first was, I believe, and I think they both relate to MWP2. First was a question by Commissioner Crosby, Chair, regarding the need to have Kaitahu involvement in decision making and a Kaitahu accredited decision maker. If you forgive me while I just find that reference. So this was at paragraph 205 of Mr. Adams' section 42A report, page 61. Just by way of explanation, Kaitahu has a pool of accredited commissioners from which it calls upon when it's asked for a nomination. Now, importantly, that includes people who have particular expertise in cultural matters, but who sit outside Kaitahu. One example of when that particular person might be called on is conflicts. It's Kitty being a good example. However, in my submission, there's nothing inconsistent with including mana whenua representatives on decision-making panels in areas within the Rohi. I say that for two reasons. It's the embodiment of partnership, which is protected under Section 8 and Article 2. There are also, what I understand that Policy 2 and M4 are aimed at driving at is in part implementing clauses 3.2 and 3.4 of the National Policy Statement for Freshwater Management. I did at one point have that open in front of me, but simply to say that policy clause 3.2 of the NPSFM is the mana te mano te wai policy, and at subparagraph 2A, it requires a regional council must actively involve tangata whenua in freshwater management, including decision-making processes as required by clause 3.4. And at 3.4, every local authority must actively involve tangata whenua to the extent they wish to be involved in freshwater management, including decision-making processes. And that includes identifying the local approach to giving effect to te mano te wai, making or changing regional policy statements, regional and district plans, so far as they relate to freshwater management, implementing the NOF, developing and implementing Mātauranga Māori and other monitoring. That's clause 1. So that's our response to the drafting. We say we acknowledge the point raised by the chair, but we say there are already existing mechanisms for protecting exactly the sort of natural justice concerns that might be raised. But that would also be no different to someone who had an expertise in a different particular area sitting as a commissioner. But they too and should hear the matters objectively and determine them in accordance with the rules of natural justice. And in relation to the funding point, which was MW4 raised by Mr. Cubitt, and if you'll just forgive me while I find my notes. As I understand it, the words here, resourcing, kaitahu participation and resource management decision-making, including funding, ways in which that might be expressed would be in the commissioning of cultural impact assessments and or in circumstances where, for example, Ōkaha or Te Ao Marama are invited to provide comments on a draft document. They are treated the same way as any other consultant that the regional council might or district council might engage, so are paid for services. And if the concern is one of jurisdiction, I rely on, in particular, the protections in section 6E, 7A and 8. It's really, in one sense, meaningless if there are to be scope for participation, but the actual necessary actions to implement them aren't available if there's in the same way that a regional council has any host of other obligations under the Act. If the funding is not there, it's just there on the paper, it won't materialise. So in that respect, I understand exactly what M42, I believe I understand what M42 is about in context. It may be a matter that the planning witnesses can speak to in more detail. Happy to take any questions.
I had a question just on the tip of my tongue until you answered it right at the end. And that was around partnership. It's the whole wide notion of partnership. And it's a follow-on to the chair's question That's good. And I actually want to throw a question, perhaps not to you, but I want to, sure one of the others is going to address it. The gentleman right to your left, for example, who I'm looking at. And that is the issue of being Ngāi Tahu and being involved in decision-making, resource consents, etc., in your own roi. The challenge that puts Ngāi Tahu people under, because it happens everywhere. You know, I mean, the notion of having tangata whenua involved is one thing. The pressure that puts that Ngāi Tahu person or persons under, can be quite another. So I'll leave that with you, Mr. Ellison, for later on when we get to you. But I wanted to raise it now because my mind was really turned to the wider question of partnership. What does that really mean? How does that really work? Having slots on a committee or group set aside for Ngāi Tahu is one thing. How you then take that to the next level, it can be quite another. And that's, I'm throwing that question firstly at you. Well, you might be calling you Aidan.
I think it's absolutely fine.
Well, I'm throwing that question firstly at you to get a kind of legal perspective on that, and then I'll leave that for the rest of the Ngāi Tahu presenters later on to give me their views on that. What does that mean? And it may well be quite different. For example, there may be particular papatipurunanga things that you do that differ or might be slightly different. And I'd really be interested in hearing some of that. Exactly. But let me just come back to you, Aidan, and throw back that question around the broader kind of things that partnership entails, particularly going into this new RPS, and in particular, I'm thinking of perhaps things that weren't there before, that you Ngāi Tahu is advocating for now, and how, in fact, you might see some of that pan out.
That incredibly broad invitation. The first comment I'd make, and it's a point I perhaps glossed over in my missions, but it can be found at the top of page 17. And it's sourced from the Tiatia decision in Southland. What does taking into account the principles of Te Tiriti actually mean? One of those is active participation by tangata whenua in decision making. And how can there be active participation without resourcing? But it also entails engagement with tangata whenua in good faith. It's, I think, akin to any concept of partnership, but partners acting towards each other in good faith. And the pursuit of reciprocity and mutual benefit. Again, while I've suggested that some of these are broader principles than just partnership, I think they speak to or help inform what it is that I suppose if you want to go back as far as the Court of Appeal and the lands decision and decisions of the tribunal subsequent and the courts in this context brought through. And the talk of protection and positive action. That might be the little something more that I referred to. The bit that, in a sense, acknowledges where the partnership has fallen down in the past and is reflected in the status quo we see today, whether you do that in terms of land ownership or economic opportunities or availability of land for cultural use, and says, well, in order to truly embody a partnership, there needs to be some positive action on the part of policymakers. than plan drafts. And so that challenge is laid down. And I think to answer the second part of that question, to encounter or to challenge and bring through those things that weren't there before, that's the element of the partnership that I say sits at the core of by Kaitahi.
Yeah, I have another example, and again, it's something between Mr. Ellison and myself as well. And this is the Conservation Board, Conservation Authority set up with Ngaitahu, where you are entitled to have a slot on every conservation board kind of stuff. That's not just taking account of or recognizing, it's there by right. Now, my mind can't help thinking, why can't that apply more broadly? You know, if it works there, why can't it work everywhere? And I know for one thing it works well, because Edward and I have been on conservation authority for a long time. We've seen it work. I've seen it work brilliantly. And again, maybe I'll leave that for another comment for you. I feel as though I'm taking up all this space. Yeah, come on.
Just really a clarification, actually, Mr. Cameron, and maybe Ms. Riddell, it's probably better to answer this, but it is around the definition of Maori land and what Ms. McIntyre is proposing, and includes reference to land owned by Tront. In a legal sense, the Tahu are actually a very big resource user in the South Island, so Tahu Forestry, Tahu Farming. Does that encapsulate those organisations?
From memory, I have to bring up the wording which we in Adam's supplementary evidence. I think it does include, I'll just reread. Yes, because it says held or claims by Te Reranga o Ngāi Tahu and or related entities. And I would take that as related entities to be the commercial arms as well.
Where that land has come through as a result of treaty settlement redress.
Okay, so that's the connection. So
that's the connection.
Yeah, that's the second part.
Ngāi Tahu Forestry buys a lot of land,
yeah,
all over the place, but it's got to have a connection.
Yeah, so that particular paragraph of the definition that refers to related entities only applies to land transferred, vested, entitled under, or part of an ancillary claim. Then that's that. I accept there's some grammar that needs tweaking in there, but it is derived through the treaty settlement process. So it doesn't apply to the land owned by Te Reranga o Ngāi Tahu, which itself has its own legal identity. I understand it.
So
yeah, so land owned by Tront or the puppets of Purunanga, they have separate legal identities and will be identified as such on titles.
And the only other thing was probably really a comment, and again, Edwin would be very familiar with this. In relation to Papakainga and etc., I was probably 30 odd years ago, I was dealing with that issue of the Silner lands and the Catlins. Council found it very hard, wanted to try and actually do what's proposed here. The problems we ran up against were Doc, I'm not sure if they're sitting in the room at the moment, Doc and Forest and Bird, etc., were really hard-lined against that. Some clauses were introduced to that plan to make sure that the purpose of that land was recognised in any consent process. But that's about as far as it could go. And what I'm kind of concerned here is that it's a nice ideal. I'm not sure how the policies are going to work with that. It's probably more of a question for the planners in terms of when you get to those matters of national importance. And I understand your argument is there is no hierarchy in Section 6, but you're still going to have those arguments. The way it was currently written, actually, I think probably gave you a little more lenience in that way. The other thing is, and I'm referring to the provisions as notified, I think it's IM Policy 2, which sets out that priority. And that also may impact on how, because the use of that land sits down below the actual intrinsic values of the land. Also slightly concerning if you're wanting to give effect to it. I haven't quite seen how it's going to work. That's probably a question I think Mr. McIntyre may answer. It was just kind of my initial thoughts around that. You know, you also noted the pastoral leases are a hell of a lot more restrictive than district plans, I think.
I imagine so.
That's all I had. Thank you.
Ellen's covered what I had. I do have a number of points which I think will be better directed at the planners.
Cameron, the seventh clause, if I can put it that way, or sub-clause for the definition of Māori land, as recommended at the moment, seems to read owned by a person or persons with evidence of kaitahu's whakapapa connection to the land, where documentary evidence of whakapapa connection is provided from either the Māori Land Court or the Rūranga or the Ngaitahi whakapapa unit. The thrust of what you were submitting is that there needs to be a link, as I understood it, between the whakapapa connection to Ngaitahi and the whakapapa connection to the land as such.
Yes. In summary.
Yeah. It's not that clear as it's worded at the present time. It doesn't have that linkage.
No, and I accept it could be clearer.
Right. Okay. Just a couple of other things if I can of clarity. Just for your paragraph 29, if we can. The difficult aquaculture settlement evidence that Mr. Stevens gave really painted a picture that you've got this settlement act, which is great on its face, but you've got to have allocated space. To have allocated space, you've got to get a resource consent. To get a resource consent, you've really got to have a recognition in a policy statement coupled with a plan. But the problem that I'm just perceiving is that the way that the recommended wording is at the present time is really putting a burden on the council to actually do that. And what I haven't yet explored with Ms. Stevens and need to do so obviously is what happens in the event that a resource consent doesn't get granted. Now, in the aquaculture settlement that occurred up in Te Tauiwi, the situation, as I understand it, was that there wasn't an ability, there was so much space allocated already in environmental terms, there was no more available. So the default was a further settlement in monetary terms as a consequence. Is that still the position with this settlement legislation? You, in the end, technically, legally, might get to a situation where you just cannot environmentally or ecologically find space to allocate. Therefore, Māori and Crown have to reach a monetary settlement.
I believe that's the case. I'll defer on that question if I may to Ms. Stevens, who has more detailed knowledge, but from a legal, I'd have to check on the legal perspective of it.
Because the worry I've got is that there's a concern just that the regional policy statement trying to attempt to lay down a rule that there has to be allocated space when in fact we don't know at this stage, at this high level of regional policy statement, we don't know that there's an ecological environmental space there available to be allocated, or whether that can be within the Otago area or the Murihiku area or wherever it might be. And I really just troubled about having that compulsory nature to something that we can't necessarily ensure that a regional plan provides with.
I'll have a discussion with Ms. Stevens in the break, and perhaps overnight, or I anticipate it'll be tomorrow morning. She's got her
No, that's fine, but it's a challenging issue, and so you need to take time to come back to us. Thank you. Just on the decision-making issue, if I understood your oral response correctly and noted it correctly, you were putting emphasis on that phrase that's been recommended to us in MW4.
Yes.
Of accredited commissioners.
Yes.
So are you, in essence, saying to us that and you use it as an example, Mr. Kirikiri, in this process, as having been nominated or essentially by budget. If that's the position, are you saying that the pool of accredited commissioners that NITO might have recourse to meet that mutual obligation of council and NITO to make available may include personnel who are non-NITO? Maybe Parker?
If they have particular expertise in the values that will be of concern to Kaitahu, conscious of what the balance of that.
So on that basis, NITO who have any difficulty with some sort of reference to the principles of natural justice having application or being, or something to the effect of in accord with principles of natural justice, i.e. a recognition after years that there is a natural justice issue that the public and NITO need to be cognizant of in the way in which those commissioners are appointed.
Do I understand, forgive me, Mr. Chair, is the concern that Ngāi Tahu may be a decision maker on its own proposal or application?
Absolutely.
So in those circumstances, that's one of the circumstances in which Ngāi Tahu has a very clear conflicts policy. And I suppose what I would want to be careful of is that by placing down broad wording and policy, that doesn't then later in time be misinterpreted by someone to mean something altogether else in terms of the principles of natural justice, because I accept every decision-making body has to comply with the principles of natural justice when it comes to whether it's hearing submissions or making a decision. I just want to be conscious that we didn't unnecessarily add confusion into the mix by bringing that in. So while I'd have to take instructions, I can see.
The problem is that without it on its face, that provision appears to be almost a warning of when you have got a conflict or a potential perception of bias, because it's requiring the council to appoint, to enable Kaitahu to appoint commissioners where there is and where they are affected. It's almost a definition of a situation where you actually would not appoint a commissioner. But I accept your argument that if you've got a pool of accredited commissioners, some of whom may not be NITO, then plainly that there could be access to those persons to avoid the natural justice problem. But at least if there was a recognition of the clause that was to accord with, it was to be exercised in accord with, that right was to be exercised in accord with natural justice, then is there a problem?
I would submit that it's not necessary, and an example would be the fast track legislation where an iwi authority can nominate a commissioner, and that's provided for in those situations, and there doesn't need to be an additional reference to natural justice because those principles exist and are adhered to in practice, and Ngāi Tahu would not be nominating somebody who's going to be in a position of conflict, and indeed I wouldn't believe that nomination would be accepted in practice either.
Yeah, it's more a problem. It's more a problem that you don't want someone being able to attack this RPS as on its face, allowing for a situation of breach of natural justice. And on its face at the moment, certainly to me, without explanation of the pool of the commissioners and the ability to appoint someone else who was non-Ngāi Tahu, and on its face at the moment, the recommended wording appears to ring alarm bells, if I put it that way. So what I'm trying to do is avoid the alarm bell. Say, how do we do that in a simple way, in a straightforward way that doesn't cause concern for Kaitahi, but at the same time, from an Otago Regional Council viewpoint, enables it to say, well, we're not contemplating or allowing for, rather allowing for a situation where that potential bias could, on the face of it, arise. So look, give that some thought.
Yeah.
And with you to address this tomorrow. Right.
Happily.
No, thank you very much, Mr. Cameron.
Thank you, Mr. Chair. Well, having said that, you didn't want to hear the sound of my voice, I seem to have taken up more than my allotted amount of time. But without further ado, I introduce and ask Mr. Allison to my immediate left. There is going to be a waiata, I understand, before the local cultural evidence and a waiata.
Ka pua wai te rakatahi e paua mā e taua mā whakaroko ki e tahi o te rakatahi e whai ana te tauka o ka tū nā marie. Te te kaupapa, te mana ki e, whakarono tū manako, me te te rakatahi e mi atu ki te whanano te motu nei whakarana kia ora e mi kia ue ka te e awai mata o ka tū
Kia ora no.
I just interrupted. There was a small typographical, small typographical errors in Mr. Allison's mihi. We're going to hand up just a very short replacement of the 2 pages, 2 or 3 pages.
Other things.
Mr. Allison will be reading from a document that he's prepared as an aid memoir. We have copies of that available if commissioners would be assisted. Otherwise, I propose it's just a short two-page document.
Tēnā koutou anō, e te umihina, I tēnei aikea. We've got a 2-page summary. Well, it's actually 2 and a bit. Summary of my evidence. My name is Edward Ellison. I was raised at Tāko in our whānau home, Te Waipounamu, on our ancestral lands that are Pat and overlook Otago Harbour. Now, I am the current dupoko of Te Rūnanga o Tāko. I was one of 2 mana whenua representatives on the Otago Regional Council Strategy and Planning Committee during the development of the proposed Regional Policy Statement 2021, and currently represent the Otago Rūnaka on the Otago Regional Council Land and Water Regional Plan Governance Group. I am also the chair of Ōkaha and chairperson of the New Zealand Conservation Authority. Te Rūnaka o Moeraki, Kāti Huirapa, Rūnaka ki Pokotaraki, Te Rūnaka o Tākau and Hokanui Rūnaka, collectively, known as Kaitahu Ki Otago, represent whānau and hapu, who are mana whenua within the Otago region. Our interests in the inland lakes and mountains and along the Matau, Clutha River, are shared with Ngāi Tahu ki Rurihiku. Our overarching objective is to build a stronger environmental, economic, social and cultural base for our people. Mō tātou a mo wha auri e muri aki nei. My evidence describes the cultural values that underlie this objective, discusses the importance of mahi kakai and wahi tūpuna, and highlights the need for enabling provisions that support the use and development of Māori land, as well as our aspirations for the restoration of the whāao. Kaitahu are bound by whakapapa to the land, water, and all life supported by them, as I describe in my paragraphs 14 to 16 of my evidence. Tribal whakapapa links the cosmological world of the Atua to the present generation, giving rise to a spiritual relationship in respect for the Māori evident in the Tāiao, and to the rights inherent in Rakatirataka and the associated and fundamental duties of Kaitiaki Taka. Māori is a life-affirming quality evident in all things, and is a measure of environmental health and well-being. Primary resource management principle for Kaitahu is the protection of the Māori. Rakatirataka is about having the mana, or authority, to give effect to Kaitahu culture and traditions in the management of the natural world. Kaitiaki taka is the practical expression of Rakatirataka and is the exercise of customary authority of the way a resource is used, managed and protected. Protecting and maintaining the Māori of species in a habitat is a critical function of Kaitiaki taka. So Panoka taka is expressed in the resource management approach of Kiuta ki Tai, which has been previously explained, mountains to the sea, which emphasizes the holistic management of the interrelated elements within the natural environment. Failure to recognize and manage connections between the whenua, why Māori and moana has led to the degradation of fresh water in the coastal environment and resulted in profound loss of mahikakai resources. On mahikakai, practices underpin the Kaitahu relationship with Otago's rivers, lakes, wetlands, moana, and the broader environment. Our cultural identity as whānau and hapu is tied to the customary gathering of food and other resources. The transmission of mātauraka from generation to generation necessitates whānau being able to access healthy mahikakai resources to carry out our customary practices. So in paragraphs 28 to 32 of my evidence, I describe the extent of the mahikakai resource that was available to our tupuna. Further, in paragraphs 52 and to 60, The Mahika Kai resource is now a shadow of what our kaumātua and tupuna once experienced due to land drainage, degradation, dredging, reclamation of wetlands, rivers, estuaries, harbours, and coastal domains. On Waihi Tupuna, we are interconnected to our ancestral places, landscapes, and taoka that reflect our histories and traditions, including Wai Māori and Wai taoka species, Ara Tawhito, Taika, and Nohoaka. Waihi Tupuna are characterised by not only natural and physical aspects, but also by the place names and associated traditions and events that bind us to the landscape, just as the landscape is a part of us. Throughout Otago, our Waihi Tupuna have been degraded or lost through development and inappropriate land uses. And our Waihi Tupuna need appropriate protection to ensure that whānau and hapu are able to fully understand and connect with their whenua as their ancestors did before them. The ability to use native reserves. In 1844, Kaitahu sold over 400,000 acres of the Otago region, the Otako block. I think it was 500,000 acres actually, on the understanding that sufficient land would be reserved for whānau to live on and to understand themselves, sustain themselves. However, the amount of land that was reserved was too small for this purpose, and in some cases was not provided at all. The loss of both our economic base and Mahika Kai resources has inhibited the ability of whānau to remain on their ancestral land and to thrive as a people, with consequential impacts on Kaitahu communities. Villages are an important way of maintaining connectedness, a sense of whānau and hapu identity, and nurturing future generations. We need an enabling plan provision for papakaika development targeted to our native reserves to allow us to use them in the ways they were originally intended. Aspirations for the restoration of the Taio. Recent changes in freshwater management have put together a greater emphasis on the well-being of our waterways and focused on the principle of the mana o te wai. In this Kaitahu, we have undertaken a robust process to formulate a definition for the mana o te wai in our takiwā. The focus on the mana o te wai in the proposed Otago Regional Policy Statement has resulted in a significant improvement in the recognition of the interconnectedness between land and fresh water. However, this approach also needs to be applied to the coastal environment to properly recognise the interconnection between fresh water and the coastal environments and between land and coastal waters. For mana whenua, protection of Mahika Kai and Taoka species and the restoration of habitat requires a whole of system approach that recognises the importance of this interconnection between land, water, and other resources. Treaty partnership. Principles of the Tiriti o Waitangi imply a partnership that is exercised with the utmost good faith. Effective partnerships mean that kaitahu are involved in natural resource and environmental management at both the governance and management levels of decision making. The development of the new regional policy statement provides an opportunity to set clear direction for all the local authorities in Otago as to how the values, rights and interests of kaitahu and the taio should be provided for, and how councils need to engage with mana whenua in decision making in management of the water bodies, coast, Waihi Tupuna and Taoka species. And that ends my summaries, and I know I've got some questions lined up as well. Have a look at it. I'll just stop there at the moment.
Just in terms of questions, there were two potential pathways forward. Each of the witnesses has prepared a brief walk through of their evidence. And it was really a matter of whether you, Mr. Chair, and the commissioners would like to hear from all of them for questioning And the question could then be answered by the relevant witness, or whether you'd prefer to comment on matters arising out of the summaries and statements as you go.
Well, I think that each of us has read the evidence and made notes and made points in relation to each witness. So I think we'll take them.
Stick with the traditional approach.
Yes. So, Mr. Ellison, if I start with you, right?
Well, I left you with two questions earlier on as well, but they are reflective of all the things that you say here. One of the thoughts that's uppermost in my mind, that was not already clear to you, is partnership being meaningful. Use the word meaningful. Partnerships on paper that say one thing, say another thing, and with all the best will in the world, you well know, there's always the chance that things slip through the cracks. They don't get picked up. They don't get done. All that sort of stuff. And I guess this exercise is characteristic of the Māori world. Really, you can go to any, and it's the same story. And I think you can sit at a deliberation like this and say, here's the way it should be, put it on paper, this is the way it should be. But it doesn't always work out that way. And your comment about this being an opportunity to set the direction right, it's almost in my mind like saying, this is an opportunity to set things right. Not just set a new direction or the direction, but to set things right on the past. And so I'll throw that as my first take to you. Just talk about that. Tell us your views on it.
Kia ora. Well, I suppose we've had over 30 years experience in building this pathway toward what we're calling now a partnership. And it was initially with section 6C, 7A and 8, we thought, oh, this is going to be great, back in 1991. But the experience has been, it's been a long journey to get to a point where there's a degree of partnership really evident in the way that we work together. We really often were probably engaged at certain points. We might have been consulted, but we could never call it partnership. We could never follow through a process like this, go to appeals. We didn't have the resources to follow, get the results we needed. It's just simply weren't in that league. And so we had a very much picking me ngā heke process going forward over the years. Learned through the storm of hard knocks what we had to do and had to build on. And I think the turning point, though, really was the emergence of the national policy statements. It started to require council better engage. And certainly by the time of the 2017 NPSFM, there was actually a requirement to make it real. And there was a change here as well, of course, within the regional council, who were really seeking to actually have a meaningful, effective relationship. We had a mana-to-mana arrangement set up. We began that in 2009. That fell over when the regional council was doing its regional water plan. And we were being asked to pay to attend and register a workshop in Cromwell, far away from Dunedin, where most of us lived. And we were highly offended by that, when we should have been properly engaged in not having to pay, even though pay our accommodation and everything else, to attend something that they should have been coming to us on. So the mana-to-mana thing didn't work for some years. We just went through the motions. NPSFM came out in 2011. then it was picked up again in 2017 and started to build a pathway in the change of executive and council actually as well. He helped change the approach. We sat down and we talked about how we would work together. They wanted to work with us. They wanted to engage with us, and we talked about partnership. And we says you can't do that without resources. You know, it might say this in the MPSFM or in the RMA, etc. And you've got, and might have this in your regional policy statement and what have you. But to give it effect and have us sitting there, there have to be resources up front as well to enable us to engage and follow through the processes and have staff who can actually do the dotting of the I's and crossing of the T's. So as you see, it's been a building process going forward. And then the Manuheta care catchment process came up, and we were asked to be a part of the Manuheta care reference group. And attending that, we immediately saw we were a stakeholder and be treated like a stakeholder. So we called a mana-to-mana meeting and says, we don't want to be in that. We want to be at your table. On your, at the time, I think it might have been policy and something else committee, where decisions were principally made and council generally endorsed. But that's where the main decisions making was made, and the council agreed after deliberating on it. So we had 2 people go in there. They were nominated by due process from among all the runanga. And then that was okay. And then there's something else cropped up. We thought that we needed to even be closer to the action. And we says we would like to be having a level at engagement at a governance level. And we suggested that we should be have a governance relationship. Council thought about that for some time, and they came up with a Land and Water Regional Plan governance group, allocating 2 seats to Kaitahi. And I think the chair, deputy chair, and other seniors were on there as the chief executive, non-decision making. But the key to it was we would be early seeing firsthand technical advice that was headed toward policy committee. And so we were able to have input there. So this has been how we've built what we see as a partnership. And we had a chief executive back in 2018 and 19, who came up with the concept of partnership funding. So we cannot operate on this partnership if you're giving us 12 months or contractual funding. We need bulk funding so we can be sure we're going to be, if we staff up, we can hold those people. They're not short term, not building expertise and losing it. We're building our capacity to be partners. So that's the journey we have been on. And I'm describing it. There's been a few tips along the way. I'm not going to get into that, but it's been positive overall going forward. And that's a 30-year, that is a 30-year plus conversation, relationship. And despite the setbacks, we stayed in the room through those 30 odd years. And that's what it's
on that question I read earlier on about the Conservation Authority sort of setup structure, you know, where Ngaitahu is on every, you know, they have a position in theirs, or in fact there's 2, I think, in some Canterbury is 2. Now, it's in that context that I asked the question around being at the table as opposed to being at the door. You get invited in the door now and then, but if you're at the table, it's quite a different thing. Now, do you see that as a part of the key to this whole review process? You know, that, again, talk to me about that.
Yeah, there's a process under local government where they had to make a decision, I think, every second triennium about Māori representation on council, which would then was old legislation, we go to a public referendum, you know where that we ended up. And so we always said, no, we don't want to have Māori representation on council because we knew what would happen. We've seen it around the country. That legislation's now been overturned and there is no referendum. In the last local government elections around the country, saw many Māori come in through that process onto council. So it has a positive. It has a positive effect in terms of getting Māori onto the decision-making table. We've watched Canterbury ECAN legislation go through, watched it very closely, actually, with interest. And yes, we're watching how that progresses forward. I do think that is ultimately the answer, because what the council needs at the table is not a Māori person who could be from anywhere, who may not have the mana whenua knowledge. They really do need to have mana whenua at that decision-making table to help inform, engage, discuss, deliberate, debate those values that are important in terms of 6A, 7A, 8, etc. And what is in Te Mana o Te Wai, etc. Those sort of things. So I strongly believe that is ultimately probably what we might bring to the table as well.
Why hasn't that happened already?
It's really, as I say, because of the referendum issue. Historically, it has just caused diversion, really, of attention to the real objective, and people have got all hung up on Māori having whatever it is, it just creates division within the communities. And here in Otago, population-wise, we don't have 50% of the population. We know where that process will go. 2/3 Māori are Mātāwaka, 1/3 of Otago, generally, across the motu. So just practicalities, really, and not trying to lose sight of the fact what the council are really needing, what our interest is our knowledge, our mātara being at that table to assist and aid the council to meet its responsibility in terms of management and protection of the dial. So it's that practical realization those pathways will not work. And so the doing away with the referendum is a good step forward. There's another step yet for that. Ultimately, perhaps that's a legislative process. Be interested to look closer at how we're following how it works for ECAN. I fully believe it'll work very well for them. So if that is the case, we would say, why wouldn't it work here?
Just if I could just sum up what I think I hear you saying, that despite all the trials and tribulations and the hurdles that had to be jumped over and sort of stuff there, in your view, this current exercise is encouraging. At least it's a step in the right direction, and that if it's enabled to go its full distance, whatever that might be, it's got to be a good thing for Ngāi.
Yes, we are happy with how we have proceeded so far through this process, and the building of that partnership that we currently have has been positive experience. And we're hopeful of a very good outcome in the ultimate RPS.
Thank you.
Thanks, I kind of following on from that, really, Edwards and the Mataraka concept. A lot of submissions have asked for some sort of definition or clarification of what that means. And I know you're an experienced commissioner, which I know you're a coastal farmer. And I think that first The first time I saw that phrase was actually in the national policy statement. Is that correct?
I think you might be right.
Yeah. So from your experience, how has that, have you been involved, I guess, in any decision-making role or plan, but where that concept's been brought in, and how has it been implemented, I guess, following on from this progression in the partnership, because there is concern around that, what that might mean. And we know as planners and that we need a bit of certainty. So have you had experience with that in your role as commissioner before?
In terms of Mount Tauranga,
Yeah, and how it's worked into plans and how it's given effect to indecisions.
certainly that's been one of the endeavours whenever I've been on hearing panels, is to draw out that Mount Tauranga or the mana whenua of these places. And I think that was instrumental in the King Salmon hearing that we did. We drew on that for our decision. There was a commission of inquiry, and it was about 7 non-stop weeks of hearing. ECAN, in the case of ECAN, we went to the marae, as we did with King Salmon. We'd go to the marae, go to their places, and even in some cases have a field trip. Made sure we'd visit places to draw that out and make it easier for our hearings panel to understand and embody that into the plans and what have you. But I would say in my time as a commissioner, that was a growing sense of thing that we should try and do. But it's certainly become much more powerful and urgent, I think, with decision makers and that. Mark Tauranga, you've seen it right through most leaders.
It's taken a long time to get from the coastal policy statement to where we are now. And and I guess it's around a lack of understanding. People like me, how do we deal with this in a planned policy? You don't quite understand it. So that's probably where a lot of the submissions are coming from, how it might work. Yeah.
If I could add a bit more, there is, once again, there's a lack of resource put into help Hapu whānau and Hapu develop and find ways to articulate in an appropriate way into the way science works and how that is adopted or implemented. And so under the National Science Challenge, there's quite a big effort being done to really to build Māori scientists who specialise in Mount Tauranga. Look, it's a generational thing, and it takes time. You hear about the language can be lost in a generation, so can Mount Tauranga. So that's another side of the issue. That's why it has to be valued, why it has to be accessed, supported, and worked and brought into these processes, so it becomes an actual thing that happens. So this is a journey.
Leading into that was your comment in your summaries in paragraph 14 around the process to formulate a definition of Te Mana o Te Wai. And excuse my ignorance on this, the principle of that, was that not a concept already understood by Tahu, or was that something that's he's laughing, so I'm obviously
That's a good question.
It's a good question, all right, Commissioner. Well, it's a legislative thing. It come up. We probably didn't have a term like that for it, mana o te wai. Some thinking people put that together and brought it into the national policy statement and cleverly said you need to talk to mana whenua to develop that, because it could be different in different places. Not a one size fits all. And so once again, that's driving this important matter of engaging with the right people of the place, and that's empowering. And we had some hui doing that amongst ourselves, and came up with that particular interpretation for the regional council. I think they had not doing this forward from memory, as the way we've described it from memory, and the way it's gone into the RPS. Oh, sorry. Thanks. And look, it's been brought into biodiversity strategy to mana to die off. And of course, that's all right too. And it's sort of trying to follow the same principle. Also, mana whenua will say, well, who's to say who has mana? You've got to be careful. And you've got to go back to the people. And you've got to be mindful of really who determines where the mana sits. So there's all sorts of things to think about. But the concept of it draws us to having a closer relationship with the regional council for the purposes of helping define. We don't define it, we actually do it with the council. But of course, they rely on us for that mātauraka element of it. So I think it's another positive aspect.
Thank you. No, I didn't want to embarrass you with your 400,000 acres, but I was reading that the other night and it said 530 or something.
Yes.
Oh, the figures in there, it's a little bit more than. Yeah.
Well, yeah, that's right. We realised that halfway through the play.
Thank you.
Yeah, I suppose just following on from what you've just been asked around Te Mana o Te Wai or Te Mana o Te Tile. I know there are, and I can't quite put my finger at the moment on who was commenting on this, but reference to a hierarchy of obligations under Te Mana o Te Wai that should refer more widely to the environment as a whole. I suppose my question is just sort of whether you think that's appropriate, and you have probably touched on it to some extent. I know we've got various things around, fixed hierarchies and a whole bunch of stuff within this document. But do you think that there is a need for such a hierarchy, and I suppose, do you think that it comes through strongly enough in the provisions that we've got sitting here? And I know we're just talking about the mana whenua chapter, but I think that sets the scene for a lot of this.
Commissioner, I think we strongly believe in the concept of that hierarchy, and that nature comes first. We have some quibbles. There's the community access and an important use they have with drinking water and what have you, and commercial coming last. We think that's quite a strong discipline and an improvement in the way the RMA works. We would have the thought that perhaps there is a mana whenua element up there in their first priority almost, because of the relationship, the connectedness, and the kinship. So we don't totally align with the way it is in the NPSFN because for that reason.
Yeah, that's come through strongly in the cultural evidence that we've got before us.
Definitely very, very important hierarchy that I think can only be for the better. Been on many hearings where sometimes the commercial element tries to get on top. Well,
Could I ask a question around that hierarchy, actually, when throwing a bit of a spanner into the works in a way, we look at the environment, then it's the health. People, everyone refers to drinking water, and then it's economic, etc. below. That middle one, to me, it's not just drinking water, it's also air, but there's also food. Well, we all need that. So how do you view that? And because we're going to hear a lot on food and fibre production. and maybe where that sits within that hierarchy. What's your sort of opinion on that? Because some people would suggest that's purely economic. Well, maybe it is in some circumstances.
I think that's allowing people to be able to live off the land in a suitable way without being overtly commercial. There would be elements of commerce perhaps in that middle one, but your big economic driving forces is in your third one, the one that can really make a lot of difference, you know. Taking
of impact on the environment.
Yeah, on the impact on the environment, where it's of scale. And I think that for people's health, they need to be able to access good food, healthy food, safe drinking water. So, and just live well off their land.
That's the magpie.
Happy to go a bit further than that. Yeah. But, yeah.
Yes.
Yes, you'll get the examples coming towards you this hearing.
Yeah, Mr. Ellison, at the end of your evidence, and you've repeated it, I think, in your summary of your evidence today, there's an emphasis on the need for enabling plan provisions for papakāinga development. What do you personally envisage by making that request? What sort of development is this?
Well, in terms of papakāinga, in our case at Otaka, we do have a Māori reserve. I think 60% of the land's been sold, and there are many historical reasons why that is the case. It was never enough for our people to live on. They become destitute. These chiefs who sold the land within a generation were destitute, or their children were. And so, and there's a whole lot of issues around with the Māori land law set up originally to divest Māori of their land, really, to be honest, which has created nothing but a minefield for Māori landowners now. So it's inhibited. It's been incredibly inhibitor to our development there. And many people have left their lands, just simply couldn't live there. Anyway, so what we have been doing as a rūnaka, we don't own any land. We're responsible for the marae, 10 acres it sits on. The trustees, they own no land. But what we do try and do is make it easier for Māori landowners who are there to utilise their land for papakāinga purposes, whatever that might mean. And so we have been getting into district plans, city plan, regional council plans, at least trying to alleviate that problem. That is only one minute issue facing the development of papakāinga or Māori lands. There are many barriers for Māori land to be utilised or not. Look, it's a hearing plus of its own to address. But so that's our position at Otaka. Try and get provision in that at least removes unreasonable barriers that are in your RMA plans, i.e. the RPS should influence every other plan beneath it.
I hear what you say about the barriers. I'm very cognizant of those. What I'm really looking for is your own personal expression of what uses can fall within the Māori term papakāinga.
Well, to me, villages are very important. Villages grow people. Villages that bring up our young ones, really, rather than leaving whānau on their own. And so that's the concept of that communal, interrelated whānau living in reasonable proximity to each other. There is a huge strength in that, retaining the culture, building our generations, holding on to our mātauraka, and all of those other things that make us who we are. So that's what I see, and there are no doing that at home. And my vision is that we must strengthen that. We cannot afford to lose our identity. I mean, if we all have to move to the city or elsewhere, it's very difficult to retain our haputanga, you know, what I call, which I grew up with, which many of our kids grow up with, and which I'm very proud of, you know, and it makes us who we are. So that's the immediate thing, ensuring the village remains a village, and people can grow in numbers there. There may be elements of it that to achieve that, we might have to do it off land next door to the reserve, because there are limitations within the land, within the reserve. So I wouldn't like to think that the arbitrary line of the reserve should be an arbitrary line to how our papakai develop.
It's common to see in plans or past planning documents, and I appreciate your criticisms of the past, but it is common to see that type of use that you've just described as being sought to be in the last 10 to 15 years enabled by papakaika provisions. Some plans you can even see papakaika zones, and it's common for them to have a provision for some sort of limited commercial activity, i.e. something related to whatever might be carried on at a lower level, if you like, a residential related type of commercial activity. Are you seeking for that opportunity, or are you seeking for greater commercial activities in a papakaika setting?
I haven't too much thought about the commercial activity, but I think there could be related commercial activity, Commissioner, in terms of the first example you mentioned, related to the functioning of a papakai, having shops or something like that. You know.
Yeah. Thank you very much for that. The next one was this issue of decision making, and we've had a very good exchange with Mr. Kirikiri about that. But and you clearly, personally, understand the potential for perceptions of bias, and do I understand those exchanges you've had with Mr. Kirikiri to indicate that the kaitohu view here in Tako is that if you've got that sort of natural justice type of issue arising, that you will call on other expertise, but you want to be able to still have the ability to nominate someone to be at that decision-making table?
Yes, sir. That's how I see it. We may not put one of our own, certainly from this area, up, but we would like to have the ability to nominate appropriate skilled person to be on that.
Preferably someone who's going to be able to have the Mātauranga background.
That's right. I've been a commissioner, sir, in Southland, Canterbury, and West Coast on RPS. And because I didn't have an interest in those areas. So we might have, just adding clarity to what I'm saying, is there could be kaitohu external to Otago who might be appropriate. But equally, I'm saying it need not be a kaitohu person as long as they have that Mātauranga, as you mentioned. Yes.
Probably the most difficult one to last, really, and that is the term mana whenua and tangata whenua. You have a personal preference as to the use of either of those, and just to set the background to the question, I remember reading years ago, now decades ago, now Sir Ta Eddie Jury's Rekohu report, where he had a couple of pages decrying the use of the term mana whenua and saying that grammatically it just wasn't accurate and it needed to be tangata whenua. Do you have a view?
Yeah, I generally refer to tangata whenua as Māori within whenua across the country. intend to use mana whenua for people who have mana directly to that whenua. And why I think we do that, quite important, because we have a treaty claim settlement across most of the motu. And I think sometimes we need to distinguish that are not mana whenua, that, whatever they do, they have to consult and talk to us just like anyone else. So it helps remind them, but also with our neighbours as well, as we grow into these roles. Changing times, we have more and more responsibilities. We've got to be clear on our paki and who's mana whenua where. Otherwise, we're misleading people.
Thank you. We'll have our afternoon tea break now, but just before we do, I thought, given what you've been saying, that it might be of interest to people in Otago, and this is at the risk of hearing self-promote in terms of a book that I've just written. But it contains within it a quote from, I think he was Thomas Hocken, and the Hocken Library here, of course, and it's appalling. Of course, reserves, it may be of interest to you to know, from time to time, large blocks of land have been purchased from natives of this island for ourselves until we now possess the whole. The total area is roughly about 38 million acres, which have cost us in round numbers, very roughly speaking, about £50,000. Of course, reserves have been made for the benefit of the interesting people who were the original owners of the soil. It is right, perhaps, in accordance with the principles of evolution and the advancement of the human race, that those who possess the land should use it to best advantage, even though this should involve dispossession of the original inhabitants. It's an appalling statement, and it's nice to reflect on how well in the last 20 years we've come from that sort of attitude. So thank you. We'll bring Oh, yeah. Thank you, Mr. Chairman.
Sorry, I need to move.
Thank you, Mr. Chair. The next in batting order is
Kia ora koutou, e raka pira, ko Rawiri Higgins, taku igo. My name is David Higgins. I grew up on the Pā Moiraki on the North Otago coast, where my whānau have lived for generations. My tupuna are from Te Rapawai, Waitaha, Kati Mamui and Kaitau. Descent with hapu affiliations that extend across the whole of Te Wakaora, or Te Waipounga, as some people describe. My evidence is a little different this afternoon, and it brings me back, it reminds me of evidence I gave before the Waitangi Tribunal on sea fisheries for the tribe. For your information, I have completed, like some of those behind me, the commissioner's training. But I essentially, when I moved to Christchurch for a short period, the tribe decided that I should not act as commissioner, that I had more responsible things to do on behalf of the tribe, giving submissions. And I've done that from Kaikoura in the north right to Awaru in the south. Different submissions on different issues in kaupapa. And I did it with the support of the pai of Kaitahu Whānau. I'm currently the Upoko Ringaka of Moiraki, and I've been in that role since 1987. I'm a past member of the Ngāi Māori Trust Board back in the day, and I had 2 stints as the Moiraki representative at Te Runanga or Ngāi. I've since handed that responsibility on to my young cousin here beside me. I just want to read my brief summary, and I'm sure you've read all of my submission, which is basically about something I know a lot about, and that's sea fisheries and the resources off this coast. I spent a lot of time with Tā Tipini, putting together, collating all of the evidence to present before the Waitangi Tribunal back in the 1980s, which resulted in the Ngāi Tahu Sea Fisheries Report and the subsequent settlements as a result of those reports. I've been asked to comment on kaitiaki taka and protecting Māori. It's really interesting, coming from Moiraki, where we have a responsibility in the Waitaki Valley in Te Manahuna. Both Justin and I quite often comment on the fact that the Māori of our wonderful awa tapu or Waitaki is managed by a person with a button sitting in Ohobi. So it's something that is dear to our heart, and we consider and always concerned about the issues of what occurs in the Waitaki Valley. Kaitiaki taka is fundamental to our relationship with the environment. As kaitiaki, we aim for optimum habitat for our mahikakai and our taoka species rather than their survival. There is a real sense of loss when we go to places to have to show our tamariki and our mokopuna that despite our kaitiaki role, this is what has happened to our culturally significant spaces and taoka. Māori is a critical element of the spiritual relationship of Kaitahu with Te Tao. We cannot have a meaningful relationship and association with a river that is not flowing, or water or land that is unhealthy. Maintaining and restoring this relationship is important to us as kaitiaki. I've always had a real interest in fishing since I was a child. My brother and I learned our seamanship skills from going fishing with my poa, or our poa, our grandfather, and eventually we developed our own fishing company. I have an extensive knowledge of our fishery and the way our people interact with it. Our iwi have an inherent understanding of the habitats, or we did until the effects of global warming have changed things in this world. To the full commissioners, I'd like to inform you that the temperature increase in the Araitiu coastal space is now 5 degrees. That's what the temperature out here in the sea has risen in the last 12 months. We developed our own fishing company. I have an extensive knowledge of our fishery. Our iwi have an inherent understanding of the habitats for the different fish species, and our fishing practices and patterns have developed in accordance with that understanding. The South Island fishery can be divided into 3 zones in each of which the fish display particular patterns of behaviour, or at least they did. The close inshore zone runs from the edge of the sea out to the range of a rowing boat, which is usually about half a nautical mile to 1 nautical mile offshore. This was the Kaitahu traditional pre-1850 fishery. The importance of mana whenua, mana moana, and the ability to fish in our own backyard was the basis of our Kaitahu fishery settlement. Many of our people are fishermen and fisherwomen. We are fishers of fish. The land sales that occurred between Kaitahu and the Crown did not cover the coastal or marine parts of our takiwā. However, when Pākehā settlers moved into the area, they started to fish our traditional waters, and then regulations had to be put in place, and eventually they led to the quota management system being introduced. A Waitangi Tribunal claim was then lodged in response to the quota management system being introduced, and a range of redress mechanisms were offered. The decision recognised that Kaitahu whānui have rakaterataka over our fisheries. The quota allocation became extremely important to us and almost single-handedly kept the tribe afloat financially during our early years. These treaty redress mechanisms lose their value, and our Kaitahu identity suffers if the Māori of the coastal environment continues to be degraded. Mahikakai practices are central to Kaitahu whānui tradition and culture. My involvement with Mahikakai began as a child was to accompany my paua and uncles on numerous gathering expeditions to the Waitaki River. The knowledge of how and where to gather Mahikakai resources is a gift passed down from our pipuna. It is crucial to our well-being that we are able to continue these traditions and pass them down to the next generations. Over time, the Otago region has undergone significant change and modification. This has adversely affected our cultural values, beliefs, and uses in Te Taiao. Taking the younger generation on heke to learn about our cultural and histories no longer produces the visual images that accompany the traditional stories and uses of the area. The knowledge of the wahi tupuna included our wahi tapu, Noahaka sites, Aratawhito, and wahi Mahikakai, and our atauka that we still hold dear today, in which we hope to pass on to our tamariki me ka nukupuna. Teaching these stories and place names, keeping the traditions alive, and passing this knowledge to our children is important to maintaining our sense of identity as Kaitahu whānui. It is imperative that the values of wahi tupuna are recognised to ensure that decision makers know and understand the importance of these places to Kaitahu whānui. As mana whenua, as well as working in partnership with councils, we are open to working with the community and landowners to protect wahi tupuna and the Māori of Te Taiao. Kia ora tātou.
How many of you people have seen the movie Boy? Aye. There's a scene in that particular movie where Boy's sitting at the table for tea, when he walks in and he puts a crayfish there. And his comment was, oh, no, not crayfish again. That's what David's talking about, isn't it? Oh, no, not crayfish again. Because if it wasn't there, you wouldn't be asking that question, which is around the whole mahinga kai sort of argument or concern, whether you're going to be able to say, oh, no, not bloody crayfish again, kind of thing. So it is important, and I'm glad it's David's turn right now, because the mahinga kai issue is one that's really, really close to my heart. And it's what I would argue defines just about everything else we're talking about here. We can talk about the political constructs and our tikanga and stuff like that, but most of it is around mahinga kai. It is kai. It's what we are. When we were preparing for this hearing, staff asked us, what would we like for lunch or morning tea? I came back, I said, hina. That was my response. But there was a statement in there. It wasn't just about being frivolous. It was that kai is important, hugely important. That's what it's the world turns on kai. And it is important to in our tikanga. Māori tikanga is around there. So I'm interested, first of all, David, in just learning more about what we loosely refer to as the kai tahu fishery. And your evidence, you talked about it stretching right out to sea and back again, but that doesn't exist anymore, not to the same extent. Can you elaborate on that, for example, and why is it that same almost picture, I guess, or vista, isn't there? You even mentioned it here, that your mokos won't see it.
Kia ora. When I was putting the evidence together for the Waitangi Tribunal hearings, Tātipini continually tried to push me out further out to sea. Now, it's pretty difficult to get a non-fisherman trying to force a fisherman out to sea further and further. But as it turned out, we managed to secure evidence through Edward's family and Evelyn's family and Justin and I and the rest of our paipai. We managed to gather enough cultural evidence to ensure that we could go as far as the land began to disappear. And those areas, fishing grounds were tauraka, we call them. They were hugely important to us. The mātauraka, Alan, we were talking about before, of those fishing grounds embedded in our families, and they're part of our history, our tradition. When we settled with the Crown on sea fisheries, we had particular rights given to us as iwi Māori, and those rights indicated that we had an exclusive right to the 12-mile limit, and from the 12-mile limit to 200 miles, which is the exclusive economic zone, we had a development right granted to us. Now, whatever that means, I'm not sure. But as time goes by, we have managed to secure considerable commercial elements that make up a pretty substantial portfolio in fishing terms. Our people still fish for fish in those particular tauraka hiika, those traditional grounds. They fish sometimes in a very traditional way. But I can assure you that our families still hold and maintain that mātauraka today, even though they may have the biggest, flashiest commercial boats in existence. They still live by that tradition and history.
Why didn't you ask what are these traditional ways? But I know I'd be impinging.
We wouldn't tell you anyway.
We'd have to take you out and shoot you.
Yeah, well, yeah, because I mean, habitat degradation and things like that.
Yes,
we understand, or at least we're all saying that that's one of the reasons. Intergenerational transmission of knowledge is another. If the practices aren't happening, the transmission doesn't occur also. So there's all, what other things are there around hiika, as I will call it, from where I come from, fishing, that that things like regional policy statements either address or fail to address? It's more of a question.
Kia ora. I guess I can give you a really, really good example of species and environmental degradation that's occurred in the last 12 to 24 months. And I won't refer to the last one, but prior to COVID, we had large numbers of poda and other species washing up on the beaches on the Otago coast, right down to Otuku and further south. The reason why those animals were ending up on the beach was because of floodwaters coming down, fresh water coming down the rivers, and flushing the saltwater areas where the habitat was for those particular species, and the animals just killed over and they died and ended up on the beach. Just prior to Christmas in your particular area, Mr. Kirikiri, you'll note that there was an abundance of seafood that ended up on the beaches after the toxic delivery of slash from the forests came down the rivers during the floods, went up the beaches and killed numerous tonnages of species. There's an example, that last one, of something that regional councils need to get on top of so as to ensure that that sort of thing doesn't continue to happen, where you're losing a huge natural environmental species out here that's really important to our people and to the community of New Zealand, and we're just losing them on one hit after one flood. And that was the toxicity levels at sea were terrible. Now, to the chairman, he will know that in Tataui, they have the same problem with the rivers disposing of a lot of that slash from the forestry, and it's killing a lot of the haimoana beds around Takaka and other areas. So it's not new just to Te Taiawara too. It's right around the country.
The thing around kai, of course, is not just sort of maintaining optimum habitat for kai. It's also around, I mean, we often just talk about survival, but that's not quite the same as maximum habitat, is it?
No. We at the present time here on this Araituru coast are dealing with a Southeast Marine Protection program, where we're going to set aside, or we're proposing to set aside, some marine reserves on the Otago coast. One of the difficulties we have in doing that is that we have to have areas that are sustainable for our native species. But unfortunately, our kelp beds and our kelp forests up this coast from where Edward lives in Otago, right up to where we live in Moiraki, are disappearing. There's your environment that's disappearing, and that means that those species are not going to have somewhere to live. Now, that is a mixture of the amount of water that's coming down the rivers during flood events and global warming. As I said, 5 degrees temperature has risen off this coast in the last 12 months.
In your evidence in chief, I think you referred to Kaitahu over the years having developed food gathering practices based on seasons and on a life cycle of species. Most of us understand.
I don't know if the rest of the commissioners understand the seasonality that we run a process where we gather our resources. Now, mahika kai is not just food. It's all of those resources we require to sustain ourselves from one part of the year to the next. So we do spend a lot of time going inland to the lakes to gather particular species. We used to, before our land disappeared, we used to go inland to gather weka, and we would ship those weka back down the awa with our mokihi or our rope or rafts. We don't do that anymore because the weka has basically disappeared from Central. So we would have our weka, our titi or mutton birds, we would have a teal season, we would have our inaka season on the coast, and that seasonality worked right around the calendar. Our mātauraka was developed around mahi kakai, the gathering of those resources.
This is a matter of interest. Do people still make mokihi these days?
Yep. Yep. Yes, we do.
Do you make them?
Yep. We make them in Moiraki.
I always thought you were really adaptable sort of person.
We put Yamaha motors on.
The other thing is around kai being healthy as well as just being available. You know, you can have my kai fish or whatever, that's okay. But I think that the ultimate sort of issue for most people is it's got to be really healthy kai that you're getting. And in the context of the RPS, how would you see an RPS contributing towards the health of kai in the tikanga sense?
Question. Particularly because we had this community hangi yesterday in Moiraki, and there wasn't much healthy food in that hangi. But jokes aside, it was interesting yesterday that a number of our whānau who were unable to partake in parts of the hangi kai because they had issues with how the kai was made in the first place. If there was too much flour, they had celiac and all the rest of the issues that go along with that. But generally, our mahi kai areas, particularly those species I mentioned earlier, are healthy food. I guess it's more about moderation rather than overdoing it. But we do tend to target species that are natural to our environment. They're more difficult to find now, and even to the extent that we do have problems finding puha and watercress because of the degradation in the creeks and what have you, the quality of the water, etc. It's not as good as it was before. So yeah, we try to continue to encourage good, healthy food.
I want to touch on a question that the chair raised earlier on around the word mana whenua. But I want to ask the question in the context of mana whenua and mana moana. All right, talk to me about that.
During the fisheries negotiations prior to settlement with the Crown, we came up with the concept. It's not just Kaitohu Whanui, by the way. It's all of the iwi who had coastal interests, including whānau Apanui. And we came up with this concept of mana whenua, mana moana. And that basically was a concept to discourage the Crown from allocating the quota assets of Tuahukai Moana, or the Māori Fisheries Commission, to ensure that the allocations were made on an appropriate tikaka basis. Mana whenua, what is in your land, mana moana, what is off your coast. So we stuck to that kaupapa all the way through the negotiations for the final settlement, fisheries settlement. It wasn't because the term was used, mana whenua mana moana, but mana whenua had been used for a long time prior to that. My cousin Justin has a different view. Well, he hasn't a different view, but he has a clear understanding of what we believe the people of the place really means in Te Reo Māori. And it's I'll let him explain that tomorrow when he speaks. But mana whenua to us is a descriptive term. It's a version of and a way of describing who we are and where we come from. Some of our relations from further north, particularly Ngāi Tuahuriri, tend to use tagata whenua rather than mana whenua. But we've stuck to the mana whenua description down here.
Thank you very much, Ihoa.
Kia ora, mate.
I guess you've probably answered my sort of questions, actually, David. Referring back to Brendan's evidence around prioritising the customary management tools and struggles with that. My question around that was going to be, I get the sense you're still fighting an up or an up current battle because of what's happening inland. You've mentioned the pressures and the floods and that. Those customary management tools, are they making a difference? Because you've talked about there's going to be more reserves. Are they improving things despite what's still happening?
They tend to be doing that. The initial kaupapa of marine reserves was to enable ordinary New Zealanders to visit the beach and to walk out onto the rocks and observe species in an environment that was untouched. That was the initial kaupapa of marine reserves. I'm old enough to remember that. But that kaupapa has changed a bit. And we now have a situation where marine reserves are areas that have a number of different environmental elements to them. And they could be 12 miles off the coast.
They're a bit different to the mataitai.
Yes. Now, our mataitai and taiapūria tools work wonderfully well if you've got a team that are based around those different tools to ensure that they have the appropriate mechanisms in place to ensure the protection of those particular areas. So, for example, there are mataitai and taiapūria at Puketaraki. We have a mataitai at Moeraki. Everyone observes the rules and regulations that we've put in place to protect the environment. So some of those things are working. I wouldn't say that the marine reserves are doing as well as they should do or could do, because there's a particular marine reserve up in Mr. Kirikiri's area that all the commercial guys have got their crayfish pots lined up along the boundary. That's exactly it.
Yeah, I guess it was around because reading Brendan's evidence, there's a lot of work gone into that, but I sense the frustration that there are still things happening up there. And you talk about the kelp beds being silted and that.
Yes.
Happening upstream, that's frustrating, that process.
It's having a huge effect on,
Yeah.
on that environment, yes.
Thank you.
Yeah, I think my question, I think follows on from questions you've had, but particularly referring to fisheries, and I suppose if we're talking about management of the coast as a whole and trying to improve the Māori, restore mahinga kai, it's pretty complicated when you get to the coast, and you've got a lot of experience with this. I mean, we've got the quota management system, you know, we've got this RPS that's before us, existing RPS as well. You've also got the East Otago Taipuri. How, I suppose, in terms of pulling all these things together, given that there's possibly some overlap, but in terms of when we're focusing on this RPS document, I mean, what are the things in here that you really think will have the biggest impact on improving the coastal environment, in your view? Are we talking about things on land? Are we talking about activities in the coastal marine area, which is, you know, what we've got jurisdiction under here? I mean, where do you think those impacts or the biggest improvements can come from?
I think it's a bit of both. We know the state of our rivers and even our lakes are pretty poor at present, and there are a lot of reasons for that. And the effect is always downstream. You add to that the fact that we now have issues around temperature increases, particularly inshore. We have disaster ready to happen. And the situation is so bad that the blue cod fishery here in Otago has always been well known. It's been a flourishing fishery, even down in Southland and Murihiku. The last pot surveys that were carried out just in the last 6 months showed that there has been a further degradation in the numbers of blue cod. We're going to have to drop those numbers again, and I'm on the national body that will do that because there's no recruitment. Now, that is a direct reflection on what's occurring inshore with sea temperatures. You have to get out to the continental shelf, which is 15 nautical miles off the Otago coast here and 12 nautical miles off Moeraki, to actually get to the colder water where the Murihiku current comes up the coast to get the colder water. And that's where the blue cod are. So I guess, in all honesty, the effects are from both this continued issue we've got around global warming and sea temperature increases and what's coming down our rivers or what is not coming down our rivers. I think both make a recipe for impending disaster.
Do you see that there's tension between the management tools that are in place at the moment?
I don't know if it's tension. The Taiapure and Mātaitai tools work considerably, they function well, even though they're managed by two different parts of the bureaucracy. They do function well, and as I said before, I think the most important thing is that those people that are given the responsibility to ensure the management of those particular tools have the key. And if they can manage those tools appropriately, we may get a few more years of sustainability inshore.
I suppose by tools, I was also referring to sort of the regional council planning tools, the planning
stuff,
wider planning stuff.
Yep.
I'm sitting here with my Western planning hat on.
Yep.
Yeah. Yeah, I'll just add too, I went to Wairakei Village for the first time last year, always driven past down State Highway 1, and we stayed there. I thought it was beautiful. Magic place.
We call it Te Pito o Te Ao, the center of the universe.
I'll certainly be back with my sequoia.
Thank you very much, and I was a bit remiss, Mr. Ellison, in not thanking you too for the picture that you painted, both of you, in the evidence we've heard, and I'm sure we can hear from others. Been very informative, and the only thing I really, the only thing that I really wanted to ask you was from a report writing viewpoint. I noticed as you read your evidence, your summary, that you often put the K in for the NG and sometimes left it out, and I just struggled. So what do we do? Do we use the K?
We use the K. I can't remember where I left it out, but I may have. But generally, I grew up with the K, as Edward has, and I generally use it, except in that particular situation where we refer to Te Rūnanga o Naita.
Yeah, well, I was going to ask you about that.
Yes.
It happened in the
We're not quite sure.
You
I think Nai Tuahariri ruled.
I do have another question, and one I forgot about before. The quota management system. My question is, how does the RPS impact the quota management system, or the other way around? Which affects which?
The effect that the RPS would have on any decisions relating to quota management would be taken into account when quota increases or decreases are considered by the ministry, the fisheries ministry, because of the environmental impact. So that's probably the most important time. Species management is a real serious issue, and a number of us are on different species committees that are responsible for the increase or decrease of quota, particularly commercial quota, over a period of a fishing year. So we would refer to some of the information we would receive from regional councils, district councils about effluent flows and what's coming out of our rivers, coming off the land, before decisions were made, particularly the inshore species, the sedentary species like hutai, like paua, and those species that you can get in knee-deep water.
Thank you.
Kia ora.
Thank you.
Kia ora.
Kia ora.
Thank you, Mr. Chair. Now, we are just conscious of time. Ms. Cook is unavailable tomorrow, and so we are proposing that she provide her evidence.
Tēnā rā koutou katoa, ko hana nui te mauka, ko tāku te awa, ko raki ira te tapu whenua, ko te ara whiwa te moana, ko Kāti Hātia te hapū. Ko kaitahu, Kāti Māmoe, Waitaha, Peiwi. Kia ora koutou, I'm Evelyn Cook, mihi ana ki a koutou. Kai whaka wā, kai whaka roko. Ko tēnei kōrero I tēnei rā. Ki oku upoko, oku te nāne, te iramutu, na kaimahi o kaitahu, te wahora, tēnā rā koutou katoa. My name is Evelyn Cook. I was born and raised in Invercargill, Waihopai. I am mana whenua rep on Invercargill City Council at this time. I am also on Te Ao Marama as Waihopai's representative. I do have some interaction at Environment Southland. I'm on the Otago Regional Council Land and Woodland Governance Group with Edward as the Te Ao Marama representative. Our other Te Ao Marama representatives, management group representatives, being somewhat compromised by the fact that they sit on standing committees for Environment Southland, so we've divided up the takiwa like that. Tika ki te kōrero kānohi ki kānohi. Ahakoa e te tui tuina. So even though I've written the submission of evidence, it is really thicker to speak face to face with you and say face to face what needs to be said. So I have a written matters. I'm very good at deviating, and you'll notice. But in my evidence as an expert cultural witness, I can supply you with my speaking notes if you wish. I'm the only cultural witness here today that is mandated to speak on behalf of Ngāi Tahu ki Mirihiku, the three papatapu runaka with marae along the southern coast, Waihopai, Awarua and Orakaparima. I'm also the only wahine amongst those giving expert cultural evidence. I therefore carry the primary responsibility of bringing these two perspectives forward for the panel. You will see that I've highlighted in my written evidence the impact on Kaitahu women of the loss of land and degradation of te pāo and the kinds of decisions our wahine face. Kaitahu wahine are strong advocates for te taiao amongst our whānau, and within Ngāi Tahu ki Mirihiku carry much of this kaupapa. I may talk about Kaitahu ki Otago and Ngāi Tahu ki Mirihiku when I'm speaking, but it is important that the panel understand that from our perspective, regional council boundaries are arbitrary with no connection to whakapapa. We are all interconnected kaitahu whānau connected to Otago. For example, I represent Wairunaka on the Te Ao Marama board based in Invercargill, but I also whakapapa to Kati Huirapa ki Puketaraki. We share interests in Matau and Catlins with Kaitahu ki Otago because of the way our tipuna lived, settled and moved through the interconnected landscapes of what is now divided into the Otago and Southland regions. As a side note, I think of Mirihiku as going to the Waitaki, but we'll leave that for another day. Matau lands and waters make up the majority of inland Otago to a whenua where all 7 papatapu runaka have an interest, and where there is no marae, and marae all coastal to the north and south of the Matau. Matau looms large in much of the kaupapa we're involved in, Ki Uta ki Tai, from the inland lakes to the coastal waters. The significance of the new RPS to us should not be underestimated, because it is the first RPS in Otago to appropriately recognise Ngāi Tahu ki Mirihiku as mana whenua in Otago, because we go right up to the Matau, to the coast, to the riverbanks. We set up Te Ao Marama to work on behalf of Runaka to achieve the aspirations of our people. And in settlement, we've been steadily building up resources for us to be able to achieve outcomes, which we can now better support in the Matau and Catlins. It is an important milestone for Ngāi Tahu ki Mirihiku that Te Ao Marama has been able to draft the RPS with ORC and Okaha, and that we are addressing you at this hearing. We've been able to champion our approach to cultural landscapes through this process, which employs the mātauranga of our people rather than fitting into non-Indigenous frameworks. This is very important to us. We invested over time in developing our own methodologies, and we need to know that they are recognised within the planning framework. I've emphasised Article 3 of the treaty in my evidence because it's often overlooked that this part of the treaty places mana whenua firmly in the community. Our whānau are living in communities all over the region. I've also highlighted that our people consider the treaty to be a benefit to all, not just a document for Māori. However, it is because of the breaches of the treaty that there is an imbalance we as kaitahu are continually working to correct, including through restoration of te taiao and improving whānau wellbeing. Te Tangia Tauira, our iwi management plan, captures the wisdom of our tūpuna, who understood the importance of protecting the mauri of the natural environment we depend upon, and it was one of the first iwi management plans in the country to address climate change kaupapa. Our whānau are deeply concerned about restoring balance in our relationship with te taiao because we are so far in deficit. We absolutely must put the natural world first now for the sake of our mokopuna and those that follow, to leave our environment in a better condition than it is in now. Mō tātou, mō ka uri a muri api nei. Otherwise, we fear what they will have to face. We have a good opportunity through this RPS to purposely respond to the threat of climate change, to address the impact of salmonids on Indigenous fisheries,
the impact of dams throughout Matau, whether they are hydroelectric dams or irrigation dams, the impact on the health of the whole river system, as well as protecting and restoring populations of tauka and mahikakai species, and ensuring vigorous species such as wilding pines and willows do not take over our whenua. We are very fortunate that the Catlins area, both in Otago and South Bend, provides our whānau with a safe place to continue cultural practices that have been handed down through the generations. So we must look after this area with great care for future generations. That includes protecting against the advance of exotic carbon forestry, which we know is a primary concern for whānau there. We've been in hui with Catlins whānau over the last year discussing this issue. Whole farms and stations have been purchased by multinational companies and converted entirely to carbon forestry, for example at Takakopa, with little prospect of active management of these forested lands. We've been able to protect our customary fisheries through establishing Punawai Kōriki, our coastal mātaitai, we put in place in 2008 through the use of our fisheries settlement mechanisms. But we also need the regional planning framework to help protect the condition of our mātaitai waters and coastline. Unless we address the risks of coastal erosion and sea level rise, especially in relation to the closed landfill at Kaka Point, and prioritise actions to prevent degradation of the area, we will lose what is so precious in this wahitauka. There are significant areas of Māori land through the Catlins like Maranuku that I mentioned, and it is in the clean whānau evidence also, and including some Sona lands that many kaitau have a relationship with, much of which is undeveloped and contributes to the health of this part of Tāaka. If the panel are interested, they can see these areas online on Kahuru Manu, which shows all the original area of the various types of land grants, not all of which are still in Kaitahu hands, and I've provided a link for that. I don't know who's got my evidence, but anyway, it's here somewhere. We support the aspirations of the owners of these lands. It is for them to make their decisions about what they want for their whānau. That is their mana, and we want to see them able to express ahi ka where they are as they wish to. It was the original intent of the land grants that they would be able to do this. So we need the RPS to reflect and honour this, to overcome historic barriers that they have faced in working with their lands. We are putting our faith in the panel to recognise the significance of these matters and support the aspirations of our whānau, to protect and restore what we value, and to create new opportunities for our whānau to thrive in their identity as kaitahu. That was the theme of our waiata, e Paua Mai Tauma, which my late partner Kelly Davis Tamari had a hand in writing. It was his passion to see the sorrows of the past transformed in the lives of our rakatahi, connecting them with their whenua, traditional mahika practices, and understanding of themselves. That is what we do as tangata tiaki. Onena, tinana koutou katoa.
Well, it's hard to argue with anything that you say, particularly around Ngaitahu Wāhi. Because I'm married to one.
She's on my Facebook page.
But I also spent many hours around the table with Sandra
Hi.
over the years.
The container.
Yeah. And so, there's no argument about that. Because that makes up the big picture that we're all talking about here about kaitahu whānui. I actually don't have any questions really to ask, but I needed to make that comment that without it's like sort of World War I and World War II. When our men went away to war, the women stayed at home, kept the home fires burning, and ahi ka, as we all know, there's a essence of being Māori. If you don't have your ahi ka going there, you're not really on board, as I say. So yeah, I take on board all the things that you're saying very much, Evelyn. I can't argue with them at all. They've come out in some of the previous presentations that we've heard, and you'll have noticed a line of questions that we've all sort of followed, in particular me around kai mahinga kai, which as I say is a really key one. The political bits of it, you could almost argue are tag-ons. It's like everything in reverse from the way they used to be in the past, where you wanted a Māori sort of interpretation of everything, you just tagged it on. Now we're doing the other thing, or if you're talking in terms of kaitahu tikaka, you tag other things onto it. And that's a key bit, I think, to the broader ngaitahu message that we're getting from you all here today, that, it's almost like it's our way or the byway. Almost, in a sense, you know what I'm getting at. And that's important in the context of an RPS, because if the RPS process doesn't recognize that and doesn't accept it, more than that, doesn't actually implement it, you don't have a partnership. You don't have an RPS that reflects the kind of partnership that we're all talking about. So thank you very much for your presentation here today, Evelyn, and I'll pass it on to.
You just go left all the time. Thank you, Evelyn. Well, my question really, we've been talking a lot today about the definition of Maori land, and the use of the reserves and now ahikai and ko, but your evidence in paragraph 24 is the first thing that brings in cultural landscapes. And I know Elsa has done quite a bit of work of that down south, and I'm just trying to get a picture of how that may look. What does that mean in terms of the planning? I've just been involved in a hearing down your way involving dairy sheds, wintering barns in a particular landscape, and it's a working landscape, which it's a cultural landscape in a sense, but it's very subjective and it winds a lot of people up. So I'm trying to get a sense of how this works in the planning sense. I'm assuming your reference to cultural landscapes is kaitahu cultural landscapes.
Kia ora. Well, we live in the century in which we live. So the landscape, even that I look at today, is not the same as the landscape I looked at as a child 70-something years ago. So I think what we're trying to do when we're talking about cultural landscapes is acknowledge the changes, look at what cannot be reclaimed, but still link our whakapapa back to those places, because that hasn't been extinguished. Even though the title on the land is no longer ours, the fact that our tupuna walked those places and left the place names that they left, that we went as children and gathered the food, those are the stories that we tell our mokopuna, who will tell their mokopuna. When I sat with Tawa, she said, this is what we did when we went there. Bringing it forward in landscape and narratives keeps it still alive. So the way we do it now is no longer in waiata necessarily. It may still be, but it's also in planning documents like these, because this is what you acknowledge. This is what Western science acknowledges, is what we put on these pieces of paper, not on the waiata that we're seeing this morning. So for me, that's what the cultural landscape, the work that we do, is accept the reality that we're in, but link it from the past. Try and advocate for the changes and the reclamations that we can make for, whilst acknowledging the realities we're in, but making sure that those historical realities are never lost. We may not be able to go back and build our house on there, or go and gather our weka or our kakapo or our temea, but we still can talk about it, and we can still use the place names and use those stories to inform our mokopuna and to inform your mokopuna about what that means, what it used to be like, what it could be like if we did a little bit of work.
So it has to be more than just an acknowledgement in a plan, though. There has to be something that will flow from it in terms of regulation or or input on anything that may occur in that area?
I guess it depends on what the opportunities are provided by the particular planning documents or the particular situation that you're in. But what it is, it continues the fact you referred to part of the Ngāi Tahu claim document this morning in terms of land loss. The fact that it's written down, that it's in the Ngāi Tahu Tribunal evidence and reports means that those are stories that are continuing to go forward and are being referenced by scholars and by lawyers and by, you know, whatever. So that's the taking the mātauraka Māori and applying it to our traditional knowledge, our traditional whakapapa, our traditional thought processes, the pathways, ka ara o ka tīpuna, ka ara tāwhito, that we used to walk through these lands and we went every year. Somebody from our whānau went through these lands and continued to grow and develop the relationship. And when they came home, they talked about it. This is the cultural landscape work that we're doing. Now that may translate into an artwork in a town, or it may translate into something that you write in a planning document that sets a scene for somebody to make a decision. We can't necessarily control how it's used, but what we're telling you is what our reality was, what our reality is, and what we hope our reality will be going forward in terms of our kaitaki-whaka.
Thank you.
Yeah, kia ora. Oh. Kia ora, Evelyn. No questions for me, but it's really valuable to have your have evidence from a Wahine perspective in the mix as well. So I just want to acknowledge you for that.
If I may, can I answer a question that Ro, I hoped would ask me, but didn't? Because as a mana whenua rep on council, I actually have some thoughts about what you asked about how that is working. We chose to ask for 2 positions on our standing committees at Invercargill City Council because we opposed pORPS on the basis that we would only get 1 seat, and as Ngāi Tahu, we are heavily outnumbered in our own takiwa. We have 2 papatapu runaka that sit within the takiwa of Waihopai City, that's Awarua and Waihopai, and we have seats on 2 standing committees. I'm not going to say it's perfect, it's far less than ideal, given that they had to agree at the end of our first year to have us back for the next year. And then they had to ask us to leave the room while they talked about what they were going to pay us. All things which I think should be sorted out. They just should be automatic, same as they are for everybody else. However, having said all that, it's better to be at the table than not to be at the table. The only thing in my experience is that we do have some councillors that are a bit confused as to whether I can talk about things like swimming pools or only stick to things like mana whenua issues. And this is why I talked about Article 3, because my citizenship right gives me the right to talk about anything that they talk about. However, I think the biggest handicap is the current local government legislation. The LGA Act talks about Māori, doesn't talk about, you know, you correctly reference the Conservation Act and the opportunities, the New Zealand Geographic Board Act as well, that provide opportunities for Ngāi Tahu to sit as of right. We don't currently have that within local government, and this is why councils are treading trickily around these things. But we have the same arrangement with Environment Southland. We have 2 people on each of 2 standing committees, and it's not the optimum, but it's better than not being there, and it gives us the ability to be decision makers about our future going forward, the city that we live in, the region that we live in. And so if it helps you at all, and you have any powers at all, and if you're ever in a place where somebody's talking about reform to the Local Government Act, this is one of the reforms that needs to happen so that mana whenua can sit at tables as of right without having to go through the hoops that we've had to go through.
Now that I can ask the question I was supposed to ask. I will now to raise it. And the question was the use of mana whenua as opposed to tangata whenua. We've asked everybody else, we've got a view there, and it is one of the kind of the take on the table. So what's your view on that?
Far be it from me to argue with my nephew, you or Ngāi Tuahuriri. However, I use term mana whenua. I also, however, don't use the term kaitiaki for myself. I'm a living person, so I talk about tangata tiaki. That's why fisheries legislation says what it does. It doesn't talk about our fisheries management people as being kaitiaki. That was something that Rick Toe and Kelly Davis were quite adamant about. We weren't going to do that. It's partly dialectical. It's the difference between pai and taumata. Some of it's personal preference. So when I talk about my role in this, I probably would say I have mana tiaki or tangata tiaki in these roles, but I'm a mana whenua person.
Thank you. Thank you very much, Evelyn. And I have no questions for you, but I just wanted to thank you for putting the rako in the ground, and you've done that very well. So thank you. Cameron, have we got time for one more?
I'm in your hands, Mr. Chairman. Mr. Tipper is here and has a very short brief that I'm sure he could summarise very quickly. Then he might be released on his own recognizance tomorrow, which I'm sure if the panel would like to take slightly later. We go on. Much obliged.
My name is Justin Pelangi Paruhi Tipa. Like David, my tupuna of Rapuwai, Waitaha, Māmoe Tahu, and my hapu affiliations extend across the length and breadth of the Waipounamu. I was raised in the Waitaki Valley within my tribal territories of Te Runanga o Moeraki, and I live at the pā in Moeraki with my whānau, so I can be involved within tribal affairs. And so I can raise my children to be connected and know the land and the culture from where they descend. I'm the chair of Te Runanga o Moeraki, and I'm also their representative to Te Runanga o Ngaitahu, which is not mana whenua, as Edward so correctly pointed out. My evidence emphasises the integral relationship of Ngaitahu to Wai and to Te Taiao. The centrality of mahinga kai to our cultural identity and our strong aspirations to reconnect whānau to their whenua and culture. As I described in para 5 and 6 of my evidence, Wai is an integral part of us, of who we are, our language, our whakapapa, and we cannot separate our relationship with water from any aspect of our being. Wai also sustains our mahinga kai. Traditionally, our economies depended on mahinga kai, and our mana and our reputation to this day hinges upon our ability to harvest our traditional mahinga kai, primarily of our waterways and our coastal areas. While we do have a number of our whānau still engaged in these traditional mahinga kai activities, the large majority have become alienated from their culture in mahinga kai due to the cumulative effects of colonisation and the significant changes to our ancestral landscape, our water, arriving from the impacts of land development, the hydroelectric schemes, as David mentioned, has impacted our cultural practices, in particular in the Waitaki Valley for us at Moeraki. But as I discuss in paras 22 to 24, the place names tell our history, and our whakapapa has also been replaced by corrupted and fabricated names within our tapuā. The knowledge that was traditionally held about these things is at risk of being lost. In addition, we're now having to deal with the impacts of climate change in our coastal areas that's really impacting our urupa, a number of which are situated on the high tide mark and are susceptible to erosion. If we have koiwi and caskets that are exposed and they fall into the sea, those areas become waihi tapu and cannot be used for those mahinga kai purposes. And our vision at Moeraki, it's really about restoring and replenishing the mauri and the mana of our whenua, of our waterways, and to make sure our lands and our people are thriving. We want to create a pathway and a framework for our whānau to re-engage with their ancestral home. Also describe in paragraph 27 to 28, the nature of Māori land ownership and the requirements of the Māori Land Court that make it challenging to develop our reserves. There's a lack of affordable housing options for our whānau, and to meet our aspirations, we need a planning framework that enables whānau to develop their land, supported by appropriate infrastructure and appropriate protection of cultural values for Māori reserves and our wider areas surrounding the pā. We also need to be fully involved in the decision-making and management of our environmental and our taonga species, consistent with our role as treaty partners. Our ability to be present on our landscapes, to teach the next generations about their identity through mahinga kai is of paramount importance to us. We need to be living at home, regularly on the land, and we need our mahinga kai species to be healthy and accessible. Councils have a role in supporting this and working with us as treaty partners to protect what is important to us, our wai, our mahinga kai, and our stories that are held within our landscape. Kia ora koutou.
Tēnā koe, Justin. Tēnā koe me taka ki te rau ngā pāpā te wharuhuia. Tara ki te paniki te tanga. Tēnā koe. One of the points you raised in your original evidence was the changing nature of our world and the environment, which for some by implication also alludes to changing our tikanga in some ways. Would you like to elaborate a bit on that?
Well, huri te ao, huri te tikanga. We know as the world moves, so do our tikanga have to adapt to meet the environments in which we live. But there's been aspects of our relationships with our kai and how we gather our traditional species, and our tikanga have been forced to adapt through either elements of climate change, colonization, territorial authorities and the rules that they impose. And so a lot of the kai and the relationships with kai in our area have been impacted. And I think just in the lifetime and the stories that I grew up with David and my grandfather that were fishing out of Moeraki. My grandfather was one of the last traditional fishermen on the east coast of the South Island that used traditional technologies. They would go up the Waitaki Valley every year to harvest kariol, the supplejack, to make their cray pots. They would travel up the valley to harvest weka. And even when those kai were available and species were still abundant, due to the rules and impacts of time, we weren't allowed access to those areas. We had the leaseholders killing weka in numerous numbers and just lying dead in their paddocks, but they wouldn't allow our people to collect them. That impacts the relationship with our kai. The same with the kariol and all those traditional species. So we're then forced to adapt and evolve our tikanga in ways that and at speed that we wouldn't traditionally pursue. And I think that's indicative for a number of kai species. We look at our relationship with the Waitaki Valley and all our wāhi tapu, or a lot of our wāhi tapu and sites of ritual and ceremony that were flooded and lost to us, and the pūrākau and knowledge that was in a lot of the caves and sides of cliffs that were all lost. So all of these things impact our tikanga and our relationship with our landscape and with our own people.
How do you see the RPS impacting on that sort of stuff? I mean, wāhi tapu is one you've raised, and with the examples that you've given. Now, my sense is that an RPS, one of the responsibilities of an RPS is to protect as much as they possibly can And in this context, wāhi tapu, we haven't really talked a lot about wāhi tapu all day today. The first time it's really come up. But I wonder if you, well, I'm not wondering, I'm asking if you would just expand on that a bit as well. You talked earlier on about urupa, e ngahorani, the way, that sort of stuff. That there's got to be more to it than just sort of saying, here's what's happened. Part of that kōrero is around, now this is what you're responsible for doing. This is what an RPS has an obligation to pay some attention to, or to recognize, or to take into account.
I think there's the opportunity in terms, as we reintegrate and reconnect with our landscape, there's places that were traditionally that have been lost to us. But as we recreate connection, as we recreate ceremony, as we recreate ritual around our mahinga kai and around our traditional lifeways, it doesn't negate the need to be creating new wāhi tapu, new tuahu in other areas that we can be bringing life and embodying our tikanga and our rituals. And I think often those places that were lost to us, what's the opportunity to create and restrict access to certain areas potentially where we can recreate that?
Perhaps if I could just expand a little, we have been developing the Waihi Tūpuna model, which we're extending out the Otago region through the district plan and the regional council as well, plans. And that does have elements of Waihi Tapu, Waihi Tūpuna, Waihi Noho, Waihi Ka, Mahi Kai, and brings in all of these elements in a way that causes us to engage with the people on the whenua. And we're able to engage with them. Of course, in the Queenstown instance, we had 80 appeals, of course. But the beauty of that brought us into the room with them and talked to them. And so we're starting to actually translate some of these things to them in a way, well, they now better understand, certainly in the council. Well, hopefully they do, because it hasn't finished the process. But really what we're doing is going beyond putting it on paper. It's causing us to engage with the community about these concepts.
Yeah.
So I think that's what Justin's talking about.
And look, we've got some real examples of that. You know, if we look in the Waitaki Valley, we've got 20 plus years of working directly with landowners. And I know some of my whanaunga, you know, when we come to things like silent files, are really nervous about sharing some of the information around wāhi tapu that's involved in that. We've probably progressed now where we've got such a relationship with landowners in our district that we're willing to share on a case-by-case basis some of those kōrero, because we know, to Edward's point, when we engage and we actually have some really good conversations with those landowners, they actually want to protect and enhance, but it's very difficult for them when they don't understand what it is other than a silent file. So I think there's lots of examples of where that's already happening, but it's largely down to the goodwill of those involved rather than any provisions and plans.
Yeah. Good. Thank you very much.
And could I just, so I want to refer to one point that everyone else has had a bite at the apple on this tangata whenua, mana whenua. I think largely terms like mana whenua, kaitiakitanga, there's all these traditional terms or semi-traditional terms that have been commercialized, and everyone has an opinion and a take on it. But if we actually look back within our manuscripts and our traditional knowledge base, yes, while we refer to ourselves as tangata whenua, and today it's become to mean Māori in general, there was also a traditional phrase that we had that sat alongside it, and it was tangata whenua tūturu te noho. And that tūturu te noho differentiated between those iwi or those Māori that held sway in a particular region, i.e. mana whenua, versus just being of having whakapapa. So I think while I don't want that term to become commercialized and used by councils and businesses and everything else, it is a traditional kaitahu term that essentially means ahi ka, takata whenua tūturu te noho.
Let me give you my linguistic which is anachronistic, I think, to a lot of people. But I've always been of the view that you can have mana whenua, but you are not mana whenua. You can't be mana whenua. You have mana whenua. And that was the kind of the crux of the question, really, was to get at that. It's become accepted now, and most people, a lot of people use it. Even when I try to correct people, they tell me where to hop off. Kind of stuff. But in reality, I mean, I suppose my view is that it's actually grammatically incorrect to say you're mana whenua. It's not right. It's not true grammatically in te reo.
Mana I te whenua.
Yeah. Anyway, that's my 10 cents for them.
Any questions?
No, I didn't have any questions, Justin, but just to thank you. Your evidence really brings home the importance of that reconnection to the ancestral land and ties in quite well with my questions around the cultural landscape and how the importance of that, how that might work. So thank you.
Yeah, kia ora, no questions from me, but just to echo what Alan said, I also, it was really good to be able to read through it. Very helpful. Thank you.
John, I was intrigued with your paragraph 23, particularly your criticisms of the Pākehā using the terms of kuri heka and awa what was another one?
Mahino.
So what is the name of the location of Mahino?
Kakau Nui. So Kakau Nui extends from the coast up to that area.
I was intrigued because I stayed on a property called Marae Weka, which was the next one up from Kiri Heka. So was that an actual name for a location?
It's another one of those
made up ones.
Yeah, made up ones.
And obviously you personally take a view that shouldn't occur. Is it?
It's not that it shouldn't.
Am I reading that right or not?
It's not that it shouldn't occur. I guess the frustrating thing is those names came about at a time where there was a belief that the Māori race and language would eventually die. And a group of Pākehā, and for the posterity of the language, decided to put some Māori names, usually on railway stations and things like that. And you've now got a group of, community members, largely non-Māori, that really want to do the right thing and uphold and acknowledge local history and whakapapa. And as a result, they give life to names that have no whakapapa to our land, that have no meaning to us. And while they're doing everything with the best intentions, I think it just perpetuates a situation for us as who hold mana whenua, who that are tūturu te noho in that area. It's just frustrating. It's just frustrating. So it's not, I guess I'm passionate about language and I'm passionate about our identity, and what that does, it just exasperates the situation or the disconnection. So I think it is what it is, but I just want to highlight that they're not our names.
We've got a couple of prime examples in our takiwā. One is Tekapo, which has no meaning in te reo, and we'll tell you the story of Takapo later. And Kura, what the hell is it? Kohuro, named after the mountain behind it. So the school kids are the ones, they're the ones that are now starting to tell their parents, let's change the name, Mum, let's change the name, Dad. Yep.
And finally, Justin, given that Te Pane Kiritanga is sadly not functioning now, are you going to take it over?
He's not allowed to.
Our focus is squarely on our own backyard.
All right, thank you very much, and thanks to everybody for thank you. And by the way, I made an error at the start of the day. I said that each day from here on we were going to start at 9:30, and that's incorrect. It's 9 o'clock. So We'll see you tomorrow at 9 o'clock.
Whakatira e mō te tātou whakakatinga te hui me tūake ki te mihi rā kātinga. I a koutou te tangata whenua. O tēnei taki wā. Tara tēnā koutou, e koutou katoa. Ai tīmata mai ngā mihi i te tīmatanga tainua mai ki tēnei haora te putungo tō tātou hui. Pai te ngā horo haere o ngā kōrero, te whakawhiti atu i ngā whakaaro, kua tai ki tēnei haora, me te mihi o ki rātou ko e hatu, ko e waruware rātou. Reira, o tira, koe no he tau koe tūnei ki te mihi ki tātou, kia pai te kapi o tō tātou hui, e mākau no tuku atu tētahi whakamoe me ti paku nei mō tātou, hei kati mō tātou hui. Let us pray. Hei mōki i a mātou i uha, hei tohi i a mātou mahi katoa, koko e no he whakakahi a mātou, te whai gloria koe i a mātou mahi katoa, he mea tīmata, he mea mahi, he mea whakoti roto i a koe, ia whiwhi ai koe te mea ora ne, e atu whaitia ne e koe, ko hi kurai ki tō mātou ariki.